All right, good morning, everyone. We are live, just so you know. We're live streaming. Good morning. Today's Thursday, February 11th, 2021. Welcome to the Judicial Proceedings Committee. Today we have 11 bills on the docket, and I'm just going to read the order. We'll start off with Senator Washington, and then we're going to go a little bit out of order and have Senator McCray with the Baltimore City Police Department go second, and then we'll have Senator Augustine third. All right, so we'll start off with Senate Bill 471. We'll then switch to 786. We'll then go to 406, 444, 443, 383, 385, 505, 400, 420, and then 479 to round us out. So with that, welcome to the Judicial Proceedings Committee. Senator Washington, I see you there. You are up next. The floor is yours. Good to see you.
Good to see you. Can you hear me okay?
We can.
Good, great. It's nice to be back. It's good to see you all again. For the record, Senator Mary Washington, 43rd Legislative District. I'm here to ask for your support of SB 471, a task force to study crime classifications and penalties. This is sponsor only. It's a very straightforward bill. Just to remind you that our task force was charged with a very important task, reviewing penalties for all criminal and civil violations through Maryland Code, to study the history and legislative intent of classifications, to look at their constitutional implications, to really figure out how those classification schemes compare to other states, to make some recommendations regarding our current statutory scheme for criminal and civil violations. And there's three key things. One, whether our violations that should be reclassified as civil offenses and misdemeanors or felonies, whether there are penalties that should be altered, and whether the state should benefit from the imposition of an actually standardized crime classification. There are a number of things that the committee was set out to do. We met twice during prior to the 2020 legislative session, really anticipating getting our work started slightly after sine die. Well, you all know what happened. So due to the pandemic, the task force was unable to meet again until November 12th, 2020. But we did have a final task force meeting that was held December 18th. We did do some work over the course of that interim. We had a lot of support. Members were very interested, but we're asking, due to the scope of the task force responsibilities and the pandemic, that first you extend the work of this task force and allow us just one more year to continue our work. We made a second recommendation, which is that we do believe at some point that the General Assembly should adopt a standard crime classification, and that we should consider a default mens rea for appropriate criminal offenses in the state. And finally, we do believe that the General Assembly should define and distinguish some minor misdemeanor and felony offenses. SB 471 doesn't enact any of those things. It just extends the due date for the report to December 31st, by which the task force can submit our report to the governor, and that we can take some type of legislative action in the 2022 session. The members of the task force, again, these were all voted unanimously. I'm looking forward to an opportunity to continue our work. So I urge your favorable report of SB 471.
Excellent. Thank you, Senator Washington. And this is actually, I think this is the sleeper bill and work group of our time. This is nothing short of significant. So thank you for bringing this forward, and I look forward to working with you in the interim and for years to come on this. This is gonna be great. So thank you for bringing this to us. Looking around the Zoom room for questions. Seeing none, I think we all know what this does. Really appreciative of your work. Thank you very much, and I'll see you soon.
And again, before I go, I just really want to thank Senator Huff, who's really been in there and bringing this, and just thank you all very much. Thank you so much. Bye.
Excellent. Thank you. Okay, great. With that, that'll conclude the hearing for Senate Bill 471. We will now move. I don't see Senator McCray, and so we will then we'll slide right into Senator Augustine. If you're prepared, we can move to you, and then we'll go on. So Senator Augustine, the floor is yours. This is Senate Bill 406. Senator Augustine.
Thank you very much, Chair Smith and members of the committee. Senate Bill 406, Local Youth Violence Review Committee. This is Senator Augustine asking for a favorable report as amended. And I hope that you colleagues had an opportunity to receive that amendment. This is enabling legislation aimed at setting a local framework that will help us address our significant problem of youth violence. The intent is that local jurisdictions do have specific situations that are best addressed on the community level, but we want to make sure that this work is guided so that we can learn from the work product that which is applicable in other jurisdictions. It is similar in concept to the statutorily authorized enabling legislation to establish a local drug overdose fatality review team or a domestic violence fatality review team that is in current law. This bill was pre-filed by Delegate Henson, who I worked with in the interim on this legislation. We brought together stakeholders to clean up the language and strengthen the legislation, including important stakeholder groups, and importantly, raising the age of review to 24 years. We've continued to engage these groups throughout. We also met with the Association of States Attorneys, who agreed with the bill, but did share that weigh in on legislation officially because there was no criminal penalty. Colleagues, a concern I've heard raised is that this may be duplicative. Please note that the amendment changing the age of study to 24 years and younger encompasses a significant group that is not sufficiently studied, if at all, in this context, particularly by the Maryland State Child Fatality Review Board, for which there is a local component, and which does review all cases under the age of 18, but does emphasize infant mortality, as I have reviewed their annual reports. And while the State Department of Juvenile Justice Services State Advisory Board does have a child fatality review in place, to my knowledge, it is not locality specific and does not assess those not within the purview of DJS, many of which are covered in this legislation. Furthermore, I also heard a request from the judges that they be removed from this legislation, and I would be open to an amendment to do just that. The intent was to try to get as many stakeholders together as possible. But if it creates untenable conflict, I'm comfortable with an amendment to remove them while maintaining as much of a robust multi-stakeholder approach as possible. In other words, committee members, I believe this enabling legislation provides an additional guiding tool to localities to address our significant youth violence problem, whose work product can be rolled up to the statewide best practices from the community level. It is with this in mind that I ask the committee for a favorable committee report as amended.
Excellent. Thank you, Senator Augustine. And with that, we'll move on to your panel. Have Dr. Webster as your primary witness. And so with that, Mr. Webster, Dr. Webster, good to see you. You'll have 5 minutes. So the floor is yours.
Thank you, Chairman Smith, Vice Chair, members of the committee, for allowing me to testify on this bill. I'm a professor at Johns Hopkins Bloomberg School of Public Health, where I serve as the director of the Center for Gun Violence Prevention, and I've also served as our co-director for the Center for Prevention of Youth Violence. Been doing research on this issue for about 30 years. I designed the first graduate course on violence prevention in a school of public health. And I approach violence using public health frameworks and methodologies. Fundamental to any successful response to address public health and safety is a thorough objective examination of the immediate and distal cause in the very specific communities where these problems occur. Many strategies that I've studied have been doomed to failure simply because they skipped this very basic step or did not take it in a rigorous manner. It's also true that unsuccessful efforts at, I'm also familiar with this model proposed to enabling legislation because I direct the Baltimore Homicide Review Commission at the request of Mayor Rawlings Blake in 2015. I was very familiar with the model that was developed in Milwaukee, and I was confident both in the process as well as seeing some of the results from it. The review process brings together multiple kinds of data, individuals to examine the individual circumstances, motives, environments where these homicides occurred. And importantly, it brings together people with different kinds of expertise and vantage points to understand this critical problem. Finally, the process is really designed to empower decision makers with data-driven policy recommendations to help prevent violence. Milwaukee's approach was studied in its initial rollout. In the police districts that used this approach, there was a 52% decline in homicides, with no significant changes in the places that didn't use this approach. Although I'd been studying the problem for about 25 years before I served on the Homicide Review Commission, I learned a great deal looking very closely at these cases, the individuals involved with these multiple kinds of stakeholders at the table. Most of the people involved in lethal violence in Baltimore had dropped out of school, were struggling academically, socially within the school system for years. The severe challenges that these individuals face as youth were not adequately addressed by any of the systems involved. The vast majority had extensive arrest histories that began at a very young age and often included illegal gun possession. Virtually all of the folks involved in these lethal encounters had not finished school. The other thing I'll mention is that the other most commonly applied and studied approach to reducing gun violence in urban settings, group violence reduction strategy, basically use the same approach. It starts with a very careful problem analysis, looking at the data, and involves the same set of stakeholders who are coming together with very specific ways to lower the risk and hold people accountable. I think the proposed legislation would enable and encourage Maryland jurisdictions facing these challenges to keep youth safe from violence, to adopt more effective strategies to prevent violence. And because, even though this is focused on youth violence, because we know these trajectories start young, I think this would be advantageous to public safety broadly.
Excellent. Thank you very much, Professor. As always, good to see you. And thank you for all the work you've done and continue to do. All right, next we'll go on to Ms. Brown. You're up. Hold on, unmute you here. There you go.
Good morning, Senators. I'm delighted to be here today to support SB 406 on behalf of the Maryland Association of Local Management Boards. My name is Pam Brown. I'm the chair. I'm also the executive director of the Local Management Board here in Anne Arundel County. There is an equity issue that is part of rising youth violence. The African-American youth are far more likely to be victims of youth violence, and we local management boards are very concerned about having a racial equity lens as we look at all legislation. The reason that we support review committees particularly is, for a start off, they're local, and I know you are all essentially local people, and we really believe that many issues can be solved locally through a collaboration of stakeholders. We all serve already on several local review committees. I serve on the Substance Abuse and Opioid Review Committee here in the county, and also on the Child Review Committee. What I particularly like about review committees at the local level is that they bring all the stakeholders together, but then they won't just look at whatever happened at the time that created the violence that has impacted the youth, but they also look at the history. When did this youth first come to the attention of what system? And then during that time, what could we have done differently, either as a school system or a not-for-profit or the police or whoever else might have been surrounding that child at that time? So I think in terms of really shining a light both on the issue, the rising issue of youth violence, the fact that it is an equity issue, and the fact that you have all the stakeholders included, that we pull records, not just from this case, but from all of the time that a child might have come to our attention where we could have intervened and maybe didn't, or didn't intervene in the right way. It almost reopens the book for a child. Maybe a little bit down the road, not just for that child then do we learn new strategies and initiatives, but it helps us to prevent for the future for other children who have not moved down the school to prison pipeline, and we can then intervene. So in closing, I would say shining a light on what is happening to our young African-American youth in neighborhoods related to rising youth violence through local violence review committees is an excellent idea. Thank you very much.
Excellent. Thank you, Ms. Brown. Next, we'll go on to Ms. Ashley Daly. You're up.
Hi, good afternoon, Chair, and to the committee. Thank you for having me here today to tell you why I personally support SB 406, which will grant counties the ability to develop local youth violence review committees. As a graduate student at the Johns Hopkins School of Public Health, I'm often reminded of the importance of information because we cannot manage what we do not measure. To be fair, violence, especially youth violence, is not a simple thing to measure. It stems from a wide range of factors like lack of access and resources, from food insecurity and underfunded schools, prior exposure to violence and abuse, generational trauma, the cycle of poverty, and systemic discrimination that impact housing and job prospects, just to name a few. To focus just on the consequences, the resulting violence of these interrelated factors through criminal punishment has not worked to stop the problem and will continue to not work to stop the problem because the complexity of the issue demands multi-sectoral discussion and collaboration. We simply cannot police this problem away. Rather, and what this bill aims to accomplish is to give counties the latitude to bring diverse parties to the table from law enforcement, the legal sector, healthcare providers, and public health officials, among others, to address the impact that youth violence is having on their localities. We know that violence begets violence, and without focus and sustained intervention, the downward spiral that disproportionately impacts communities that are low income and communities of color will continue. We have a duty to ourselves and our communities to promote safe and secure environments for our kids to live in. With this bill, we have an opportunity to make good on that commitment. Thank you for your time today, and I hope you will vote favorably for SB 406.
Excellent. Thank you very much. And with that, I believe that concludes the testimony for Senate Bill 406. All in favor, no opposition. So with that, Senator Augustine, thank you very much. And we'll see you soon. Thank you for your panel. Thank you. That concludes the hearing for Senate Bill 406. We'll now move on. Oh, actually, sorry, Senator McCray. You know, I'm sorry, Senator Castley, I did not see your question and the senator is gone, but maybe the two of the panelists are left. So you might be able to get satisfaction there.
I'm sure they can. It's really just more on the technical side. So just sort of in layman's terms, I guess really for Dr. Webster, he'd probably be the best one to answer this, I think. I guess, but actually both of these folks were on the technical side. So reading through the bill, I'm just trying to cut to the chase here. So this board would be in each county, right? One per county at their election, right? And they would then review records related to, is it homicide or it's homicides or serious injuries? What files are they reviewing?
Yes, my understanding is going to cover not only the lethal violence, but serious injuries from violence as well. It's very clear from research I've done that, not surprisingly, there's a great deal of overlap in the set of factors that are involved. If someone is shot, for example, or stabbed in a serious manner. So it makes a great deal of sense to look at both together.
So we're looking at, and we're looking at the victims, either deceased or seriously. We're looking at their records. What are we getting from those records? I'm just missing. What's the point of that?
Sure, that's a great question. Typically in these review processes, we are looking at all the circumstantial factors. They begin with the victim because that's sort of where you have the most information. But they also will include information about, who did it, why, what other information it can be brought to bear to understand the nature and causes of these incidents. And the last thing I'll just say is, it's very important to understand the set of risk behaviors and contexts for the victims, because they're often shared with the perpetrators of the violence as well. So we gain a great deal of knowledge of understanding all these set of factors that lead to a set of often risky behaviors and conditions that contribute to violence.
So I'm looking on page 5 dash, it's 1605 lines 20. And you know, getting the records of a individual probably is, I don't think we have as much privacy about deceased individuals. You look in coroner's reports and stuff. So I'm not sure, but I don't think there's much. But this would allow this local board to get access to the victim's medical records, which immediately, it says any provider would have to give immediate access to medical records. And I just don't know how we do that under the current HIPAA laws. I don't think we have the ability to just say, this local board wants to see your medical records, Johnny, so cough them up. I'm not against the bill, believe me. I appreciate your work, Dr. Webster. My questions are more towards the technical side of the bill.
Sure.
The more we look at this stuff, and you know, I'm not disputing where you're going with it. I'm just got some more technical concerns with the bill.
Maybe Senator Augustine is best able to respond to that question. I'm not sure.
Yeah, I apologize, Senator. I thought that the hearing was over, and so
I was slow. I was slow, Senator. I'll take
That's
that.
my fault. Yeah.
But thanks for coming back.
Yeah, I mean, I'll try to come back as soon as I'll try to get back.
Yeah.
And Senator, I'm either happy to try to answer now or work with you through.
Okay, you can come back. Let me hit. There's a couple of technical questions. I'll hit you with them right now. You can always get back to me. Okay.
No problem. Okay.
All right. And these are just. And then it says that on page 5, line 6, it says that they have to provide records of social service agents that provided services to the person or the person's family. So I'm not sure which person we're referring to here. I guess that's the victim, maybe, who was either shot or killed. But then we still have a problem with that, because to say we're going to just waive, I mean, all these social services are provided they're all covered by HIPAA as well. So I'm not sure how, unless they agree, how we get any of those mental health records. Again, if the person's deceased, we probably have more latitude, but I'm not sure of that. I mean, I guess the state, if you get the records subpoenaed by the state's attorney, I guess it's a little easier to review those, but you might have problems on this. And then on my next question is on page 6, line 18, section E. It says a violation of this subsection is a misdemeanor. I'm just not following what those violations would be. I'm trying to think through just hypothetically, how do you violate the subsection? So whatever you can give me on what's a violation. Those are my questions. I respect Dr. Webster's work. He sees a good process here. I'm not disputing that. My questions are technical. So Senator Augustine, if maybe you just get back to me with some answers on those. I'd be glad.
Absolutely.
I'm not trying to hold your bill up. So
no, absolutely. We want to get those things right.
Yeah.
And Senator will definitely get you those answers.
Yeah, Dr. Webster's done some great stuff. You give him the data, he produces a lot of insight and good analysis for us as policymakers. So I'm not disputing that at all. So
okay. No, I appreciate that. We'll make whatever changes that are necessary, Senator, and I'm happy to work with you on that.
Okay, thanks a lot. Take care.
Thank you.
Excellent. And my apologies, Senator Augustine, I didn't see his hand up, so.
I'm sorry, I was quick too.
Digital gavel almost came down. All right, with that, looking around the room for questions, checking it twice. All right, with that will conclude the hearing for Senate Bill 406. Thank you, Senator Augustine.
Thank you.
All right, now we'll move on to Senator McCray with Senate Bill 486.
786.
Senator McCray, the floor is yours.
Thank you, Mr. Chair. For the record, the bill is Senate Bill 786.
My apologies. Yes.
No problem. Yes, sir. And for those, just for the record, Corey McCray, 45th Legislative District Senator. I come to you on a bill that has been heard a number of times. Once when I was in the House of Delegates, and then back in 2019. It wasn't heard last year, Mr. Chair, but we are bringing it. The administration is bringing it before us this 2021 session. This bill deals with local control of the Baltimore City Police Department. I want to first applaud, and I'm not only joined by my mayor, but I'm also joined by our city solicitor, Jim Shea. I'm also joined by our government relations person, Natasha Mehu, to talk about a measured approach in reference to returning the Baltimore City Police Department to the city of Baltimore. I think that it's a measured approach in reference to there are a number of things to take into consideration. There was also always a charter amendment that needed to be put forward, which is also in the bill. But this moves us in the right direction where you have unison support from the respective Baltimore City Senate delegation. We haven't had it, but this was also worked out with all of the senators to figure out what was a measured approach in going forward. I know that there will be amendments that are coming forward dealing with the year, Mr. Chairman. There will also be amendments dealing with the members of this advisory board that's within side of the bill, but I'll let our mayor speak on this part of it. And I don't see him popping on the screen, but okay, all right, he with us. So I'm gonna go ahead and throw the ball at him at this moment, and I'll just close with saying, hopefully we can get a favorable report as we get the amendments to you, Mr. Chair, for Senate Bill 786. Thank you.
Excellent. Thank you, Senator McCray. And we're working to incorporate this with our package. So definitely a priority for the committee as it's come out of your delegation. So thank you for the work. Your primary witness today is Mayor Scott. You're here, you're up. So the floor is yours.
Thank you. Good afternoon, Mr. Chair. Good afternoon, Vice Chair, members of the committee. As you know, I'm Mayor Brandon Scott here in strong support of Senate Bill 786. I want to thank my Senator Corey McCray for introducing this bill. This bill is a top priority of my administration. Local control of BPD is about racial justice, about police accountability, and it's about representative democracy. As you know, because we've had this discussion for many years, Baltimore is the only jurisdiction in Maryland that does not directly oversee its police department. We've been paying for that lack of local controls for over 160 years. This bill will put the city in the same posture as jurisdictions across Maryland. I have led the advocacy on this issue, Mr. Chair, for nearly a decade when introducing my first legislation into the city council as a young city council person, trying to require data to be shared from the Baltimore Police Department, only to find out that I couldn't require that through law because it was controlled at the state level. We are now living in a moment where we have the opportunity to make real change in a new way. Local control paired with statewide police reform efforts being considered by this body, in addition to our consent decree, will go a long way to ensure meaningful transformation. The ability to set policies and provide oversight locally will enable us to truly transform BPD and fulfill our consent decree requirements. We've heard about those concerns and hope changes to the bill that Senator McCray mentioned earlier will help address and alleviate concerns from many folks about the timing. This bill would establish, as you heard, an advisory council of key stakeholders to guide and oversee the transition. I always like to do things in decency and order, but also do in the right way so that we don't have to consistently come back. To address the liability concerns, the bill clearly states that BPD will be considered as an agency and instrumentality of the state for all actions, omissions, or events that occur prior to the date of transfer, and will be considered an agency of the city for those same considerations after the transfer. To ensure residents have a voice in this matter, transfer of the control is contingent on the passage of an amendment to the Charter of Baltimore City and its ratification by the voters of Baltimore City. The steps in this bill afford the state, BPD, city government, city delegation members, and stakeholders the necessary time and process for guaranteeing the transfer occurs with foresight and precision. And to ensure we put forward the best bill possible, we're working with our coalition of stakeholders to improve what is before you. Senator McCray mentioned that, and to that end, we will pursue amendments to shorten the implementation timeline and include additional voices on the advisory council. With increasing calls for police transparency and accountability, now more than ever, Baltimore City must regain the authority to oversee its police department. We look forward to working with the committee and our partners to make sure that is a successful reality. For those reasons, I urge a favorable report on Senate Bill 786.
Excellent. Thank you, Mr. Mayor. Good to see you as always. Next, we will move on to Mr. Shea. How have you been? Good to see you.
Good to see you, Chairman Smith and members of the committee. Good afternoon. I'm Jim Shea, City Solicitor, and here to support Senate Bill 786. The testimony that I'm going to give will relate to the question of whether, if Baltimore's police department becomes a city agency rather than a state agency, that there will be an increase in civil judgment liability that the city has to pay for. It is my opinion that there will not be such an increase. In order to fully analyze that question, you have to look both at state and federal law, state tort law and federal constitutional section 1983 law. In both of those cases, the city already pays to the full extent that it could be liable, because notwithstanding various immunities that seem to exist, the easy route to a judgment is a suit against the police officers, which in both the state and the federal system can proceed to judgment. And in both instances, the city is required to pay that judgment, whether or not it's an actual party to the suit. In the state tort realm, it's the Local Government Tort Claims Act that requires the city to pay judgments against the police officers. In the federal arena, it is the collective bargaining agreement with the police that again requires the city to pay any judgments against police officers. And therefore, there is a rule that there's only one judgment that a plaintiff can get. Any further liability, direct liability against the city is immaterial. The judgment already has to be paid. On the federal side, even if the collective bargaining agreement could be changed so that the city isn't required under it to indemnify its police officers, there still would be no improvement in its liability position if it became a city agency. And that is because the 11th Amendment, which provides immunity in 1983 suits to state agencies, is not helping the city at all today. There are two federal court decisions that hold that the city is not entitled to that immunity, that it is not a, quote, arm of the state, which would be required to get that immunity under the 11th Amendment. The test that is applied in those two federal cases is a multi-factor functional. I'm sorry, am I still on?
Yes, you are. Go ahead, please conclude.
All right. It's a multi-factor functional test, and there are four elements. Is will the judgment against this entity affect the state treasury? Answer no. In the situation today, situation after it becomes BPD becomes a city agency. Second factor, the agency's degree of autonomy. Today, the autonomy is substantial in the city, not in the state. Third, will the agency does the agency deal with state or local concerns? And the police department deals with local concerns. Its predominant, if not exclusive, jurisdiction is the city. And fourth, how is it treated under state law? So under this functional test, the city is not entitled to the 11th Amendment immunity anyway. It is not considered an arm of the state, and therefore changing it to a city agency will have no difference. So in both federal and state law, a change of the Baltimore Police Department to a city agency will not materially affect the civil liability that the city will have. And for those reasons, I urge a favorable report on Senate Bill 786.
Excellent. Thank you very much, Mr. Shea. Actually, that was you addressed head on a lot of the questions that have been asked in this committee about the different, and I'm sure you'll get to more questions about the difference between state sovereign immunity, local tort claims, and 1983 claims in the federal realm. So, but this shed a lot of light on that, and these are questions that we've had for a while in this committee. So, thank you very much. It was spot on. Next, we'll go on to Ms. Mayhew. I think you're there. There you are. Good to see you.
Good afternoon, Chair, members of the committee. Natasha Mayhew here on behalf of the Mayor's Office of Government Relations. I think my Mayor Scott, as well as Solicitor Shea, had provided strong testimony in support of the bill. I'm here to assist in answering questions should the committee have any. And with that, I urge a favorable report.
Excellent. Thank you very much. All right, next we'll move on to Mr. Young. I think I saw you down there. There you are.
Greetings, Chairman Smith, Vice Chair Wildstriker, members of the committee. My name is Kalen Young, the Director of Public Policy at the ACLU of Maryland. And we are here in strong support with amendments for Senate Bill 786 to finally set a pathway to restore local control of the Baltimore Police Department to the residents of Baltimore. This is one of the five core reforms we are pushing for as part of the Maryland Coalition for Justice and Police Accountability. This is also a primary goal of the Campaign for Justice, Safety, and Jobs. I want to thank my Senator McCray, for introducing this bill, and as well as my former boss and Mayor Brandon Scott for not hesitating to fulfill this campaign promise. As you know, the BPD has been a state agency since the Civil War. Additionally, until very recently, the state legislature has provided minimal oversight to the BPD. This has contributed to what the BPD monitor Ken Thompson referred to as a culture of corruption. He made this statement during a consent decree briefing before the Judiciary Committee in 2019. In the same briefing, the then new Commissioner Mike Harrison further stated, and I'm paraphrasing, a corrupt police force cannot reduce crime. You must eliminate the corruption first before you can see sustained crime reduction. Local control allows the city council to provide the necessary oversight that it has been, but now with teeth, to hold the department accountable. The Community Oversight Task Force also has said that local control was needed for full implementation of the consent decree. Local control of the BPD is about racial justice, police accountability, representative democracy, and self-determination for the people of Baltimore. Implementing local control and ensuring a robust community participation is essential for building bridges of trust between the administration, Baltimore's Black communities, and Baltimore City residents as a whole. The ACLU and CJSJ are offering a set of amendments to expand the advisory board to include more community members, require the advisory board to complete its final report by May 1st, 2022, move the charter amendment ballot question to from the 2024 election to the 2022 election, and to move the transfer of control from 2025 to 2023. And with those amendments, we would urge a favorable report. Thank you, Mr. Chair.
Excellent. Thank you, Mr. Young. I see you, Senator Jackson. We have one more witness left, and we'll go to Senator Jackson for questions. Ms. Chaudhry, you are next. Good to see you again.
Good to see you again as well. Thank you so much, Chair Smith and members of the Senate Judicial Proceedings Committee. I thank you on behalf of CARE, the Council on American Islamic Relations, for this opportunity to testify in strong support of Senate Bill 786 with amendments sponsored by Senator Corey McCray to make the Baltimore City Police Department a city agency. This bill is critical because after 160 years, it would finally restore control, as mentioned, of the police department to the city of Baltimore and foster public accountability and trust between city residents and the BPD. I personally on a personal note, was born and raised in Baltimore, Maryland. I attended Store Hill Elementary School, Franklin Square Elementary School, West Baltimore Middle School, and Western High School. Growing up, I personally witnessed and experienced the harmful impact of mistrust in law enforcement officers in my own neighborhood, prompted by the lack of transparency, accountability, and relatability. It hindered community safety and effective policing models. For over a century and a half, BPD has been the only local police department in Maryland designated as a state agency, thus prohibiting Baltimore's mayor and city council from being able to implement meaningful policy changes that influence policing. These measures must instead go through the General Assembly, a body that only meets for 90 days annually and is far removed from the city of Baltimore. This bill, we believe, sets a path for restoring to Baltimore the same degree of control over its police as other jurisdictions. CARE is part of the Maryland Coalition for Justice and Police Accountability as well. The coalition's position is that this bill should be amended so that the issue of local control can be included on the 2020 ballot with an implementation date of January 1st, 2023. We are also concerned that the advisory board does not explicitly include community members. We believe that this bill should be amended to remedy that. Senate Bill 786 would positively contribute to effective policing in Baltimore and enable local lawmakers to take steps to enact meaningful reforms. I respectfully urge the committee to issue a favorable report on this legislation with amendments to shorten the implementation timeline to 2023 and to include community members on the board. Thank you so much. I yield my time.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 786. We'll now turn to the committee for questions. Senator Jackson, you're up first, followed by Senator West.
Thank you, Mr. Chairman. Thank you, Senator McCray, for bringing forth this legislation. We served in the House together, and I've sort of watched this trek and this journey for you all in the city. And also congratulations, Mr. Mayor and Mr. Shea and some of the other folks that are familiar to this panel, to this body. Senator, can you, I sort of could gauge over in the House. I just got over here to the Senate. So what's the, so are the senators from the city on board with this process as well?
Senator Jackson, I truly appreciate the question. You know, first, before I even dig into the question, I want to acknowledge that we do have 2 city senators on this respective committee. And it is because of the leadership of Senator Carter, Senator Sidnor, Senator Washington, Senator Hayes, and our President Ferguson, where we have got to a point where we have consensus in reference to moving in the right direction on this respective issue. And, you know, being able to coordinate with our mayor and have communication about the issue in a time frame in which it's not something that's rushed. It wasn't something that, you know, coming at the end of a session or things of that, to thoughtfully discuss this issue through and through prior to getting there. And this is the product that we've come up with, and obviously the amendments that we have, but this does not happen without the city senators as a whole. Thank you. Thank you for that question.
Absolutely. Thank you, Mr. Chairman.
Excellent. Thank you, Senator Jackson. Senator West, you're up. I couldn't tell if you were frozen because you had that stoic look. I thought you were screaming frozen.
No, I wasn't frozen. Senator McCray, I really appreciate your bringing this bill, the more so because I introduced a piece of legislation earlier this session, and part of my legislation was word for word identical to this bill. So obviously I'm totally in support. I've never been able to understand why the Baltimore City of all jurisdictions does not control its police department when all the other jurisdictions in the state do. So the one respect in which my bill differed from this one is in the implementation section on the last page of the bill. This bill provides for a ratification vote in 2024. And I guess my question is to my old childhood friend, Mr. Shea, as to why we are going to have the ratification vote in 2024 as opposed to 2022.
I'll answer that, Senator West, and it's good to see you again.
Good to see you. I want to jump in after you too.
Yeah, I'm about to defer really to those in charge of the policy. It's not really a legal consideration. We do have to get a charter amendment done. So there is a timing factor there from the law, but I think it's really a matter of policy, and I will defer to Senator McCray on that.
Thank you. I guess the question is, where do you see inside the bill, Senator West, where we are requiring that a charter amendment go on year 20?
It's on page 4. It's section 4 of the bill. It says, be it further enacted that Senate sections 1 and 2 of this act shall take effect July 1, 2020. Excuse me, January 5.
President.
And contingent on the passage of an amendment to the charter that it goes on for a while, that will be set before the voters in the 2024 general election.
Got it. So I'm not sure if you heard in the respective first comments. I was the first member that testified on it.
Yeah, I'm sorry. I was in a different committee presenting a bill. So if I'm replying on the ground, I'm sorry.
No problem. I'm gonna dig into it again. So I said it in my first comments, and then as Senator Jackson asked his question of the city senators, I then referenced it again. But we're going to be changing the implementation date to 2023, Senator West. And it doesn't happen without it going on to 2022. So that issue is addressed. I couldn't remember the bill number. And I know that you did sponsor a bill in reference to local control. I would like to acknowledge that it was not word for word, Senator West, respectfully. And
it was close.
And if respectfully, I'm not from Baltimore County, but if you would have come to the city senators, we would have been able to tell you that we were working on the issue. So I appreciate that you do care about the issue, but we also care about the issue. And I just wanted to
sure, absolutely. And in fairness, my bill was an omnibus bill that covered a lot of ground. This was I think was the first element of the bill, but there were lots of other elements in the bill before you.
Yep. And I would just say respectfully, just as the chair of the Baltimore City Senate delegation, that if I had an issue that dealt with Anne Arundel, Hartford, Montgomery, Baltimore County, I would also make sure that I reach out to those respective members in that respective delegation. Thank you again.
Sure.
Well, he walked into that one, didn't he? But all right. Senator Castley, you're up next.
Thank you. And I'm not sure who I'm addressing this to, but I guess anybody in the panel. And that's just as a practical matter, assuming the proposed charter change goes through, what would, as a practical matter, what would change here? What can't you do today that you would be doing after the 2023, assuming the charter amendment goes through, after the 2023 charter amendment? What would we expect? Or what options would you have? Let me put it that way, that you don't have now. Baltimore City, excuse me, not you.
Jim, I'll take it first, and then you can take a second stab at it, just to add on to what I'm saying. So currently, Senator Castley, the mayor has the control over the police department, but folks also want the city council to have the opportunity to be able to weigh in on our respective police department. Mayor Scott talked about that, how he recognized and referred to some reporting efforts that he wanted to make while he was a city council member, that he was unable to do so at that moment. And that's the main gist of what I believe is just making sure that the city council has the opportunity to weigh in on their respective police department. The mayor has that power already, but just making sure that the city council and city solicitor Shea, if I'm obviously you're the lawyer, but if you want to add anything to that piece of it.
Well, I think it's a wide range of possibilities, but I'll give you an example. If you wanted to change the Baltimore City Police Department's jurisdictions, which is Northwest, which is Southwest, the city can't change that. They'd have to go to the General Assembly. If one district has grown too large by geography or population, the city couldn't change that. They have to go to the General Assembly because it's technically a state agency. So it's hard to anticipate every way in which this would change. But I think clearly there are operational details that should be within the city's ambit that are not now.
So, I mean, been sitting on JPR for a while. I just haven't seen any of those. I don't recall those changes coming through. I have heard just through news reports often of the police commissioner, who I assume was a member of the city council. Am I misunderstanding what that individual's authority was? Or
yeah, no, the police commissioner of Baltimore is not a member of the city council. No,
I'm sorry, I didn't mean the commissioner. I thought there was a member of the city council who was like some authority with regard to the police department. Is that not the case?
Well, there's a public safety committee, but that carries with it no authority over the police department.
Okay. So, I mean, this would then say that the city council could pass an ordinance changing the jurisdictions, but I don't think we haven't been approached to do that I know of, change the jurisdictions. I guess they haven't changed it.
I actually had that bill, Senator Castley. What happens is it was the bill where we haven't changed our respective districts that Jim's talking about, non-police districts, just for the record for the committee, so that they know, is non-police districts haven't been changed in the last 60 years. We passed a bill 2019 that would require the police commissioner to change them every 10 years after the respective census is done. This is one of the other initiatives that Councilman Scott is working on prior to him becoming the mayor. And I want to give a shout out to, Ken Harris, who was the one that actually started the issue before his unfortunate death. So just acknowledging that, but that was one of the efforts that I led. So every session, we got about 2 or 3 police bills that are put forward that has to go to your respective committee prior, and Baltimore City isn't unable to do that. But I also want to acknowledge that the police commissioner and any one of those police commissioners could have took that action without legislation, but we put forward to require them to do that.
Thank you.
All right, excellent. All right, thank you very much. All right, so I'm going to go to Senator Sidnor and then Senator Carter. Senator Sidnor, you're up.
Thank you, Mr. Chair. And this isn't a question, but just as I listened to Senator Cassidy's question, I just wanted to give a real life example. I would say some years ago, I had a relative whose car was searched by Baltimore City Police Departments, and they tore it up. I think they had mistaken the vehicle that my relative had with another vehicle that they meant to search. It was a brand new Lexus, seats and everything were torn up. So he filed suit. And when he filed suit, like anyone in any other jurisdiction would have thought, you would have filed it against that jurisdiction. So he filed his suit against Baltimore City. And Baltimore City's response was somewhat, he filed with the city. Their response was somewhat delayed, and by the time that they responded to his complaint, where they let him know that you don't file those types of complaints with the city, you file them with the state, he had no time to do a timely filing with the state. Hence, he was kind of left with the bag. So this is something that's a benefit to citizens who are trying to get when they have issues with our police department. I just wanted to say that. So thank you.
Excellent. Thank you, Senator Sidnor. And Senator Carter is up.
Thank you, Chairman Smith, and thank you, Senator McCray. I don't think Mayor Scott is still here, but Representatives, Solicitor Shea, it's good to see you in Annapolis. Hope to see you on more issues as it's pertinent. I want to say a few things. One, when this issue was proposed previously, and also was proposed by the Community Oversight Task Force that was under the consent decree, I initially had skepticism about it. And why did I have skepticism? For a couple of reasons. I had skepticism because the City Council has routinely over many years approved every single police commissioner and every single budget and every single supplementary budget. And so my initial thoughts were, well, why should we entrust this group to be accountable? Over the course of many years, watching some of my colleagues as well as myself try to propose changes to the police department and being met with such incredible resistance and skepticism by some of our colleagues. Like I remember last year, I believe it was Senator McCray, you attempted to simply solidify one of the things we know is critically important, which is that police officers should, for the most part, live in our city and invest in our city. And many of our colleagues are like, oh, but what about our friends and family that live other places but want to work in Baltimore but don't want to live in Baltimore? So I'm very, very happy that we're at this point. I want to say that this, coupled with the other changes that need to be made, such as changing the Law Enforcement Officer Bill of Rights and giving transparency within the ability to access disciplinary records of police officers, these three things, this trilogy of things, will now put Baltimore City in a position where there's no more excuses, because all accountability will lie on the City of Baltimore for everything. And I think that's a good thing, a direct pathway to accountability. No more blaming the state, no more blaming the Law Enforcement Officer Bill of Rights, none of that. So all of that being said, I'm very happy and supportive of this legislation. I do have to mention that the prior people that supported it over the years, including myself last year, the bill was not given a vote at that time, but I don't think we had built the level of consensus that Senator McCray was able to build. All of that being said, the question that came up earlier in this hearing about ballot, the ballot question, can you answer, any of you, when would the City Council have to grant approval for this to be on the ballot for, is it possible to be on the ballot for 2022? Or what's the time frame?
I believe it is, but I think it's more of an appropriate question for City Solicitor Shea, because I know it has to be introduced by one of the council members, passed by the council, and I'm not sure if it has to go for charter review, and you should be, I know that you may be able to explain it a little bit more, City Solicitor.
Mr. Young's got his hand up.
Oh, okay. Oh.
I'm fine to cede it to Mr. Young. but I do think there's time. Go ahead.
Thanks, everybody. So my previous role before coming to the ACLU was the legislative director for then Council President Scott. Part of that role required, getting the legislation through the council in time for charter amendments to be passed. A charter amendment can get passed as quickly as really 1 month. It takes about 3 council meetings to get it done. So as long as we amend the reporting requirement for the advisory board to be early May, we could certainly have more than enough time to get to what would usually be the deadline of roughly late July to early August to get an amendment onto the ballot. Real quick, while I have the floor, if you don't mind, Mr. Chair, to one of the questions that talked about what are the examples of how the city council doesn't have power. There was a few years ago where the city council wanted to mandate body cams for all of the Baltimore City Police Department. And it was at that point that the city law department informed the council that they were not able to do that as a result of not having local control. Additionally, there was an overtime fraud situation occurring in Baltimore City for the last few years. And it wasn't until very recently that changed as a result of public pressure. But indeed, had the city council had local control, they would have been able to make that change as well.
Excellent. Thank you, Mr. Young. Looking around the room for additional questions from the panelists, just want to say thank you, Senator McCray, and thank you to the Baltimore City delegation for the hard work. And we'll obviously, in deference to you all, we'll work in earnest on this. So thank you very much. With that will conclude the hearing for Senate Bill 786. Thank you, Senator McCray. Next, we'll move on to Senator Lee with Senate Bill 440. Senator Lee, the floor is yours.
Thank you, Mr. Chairman, Mr. Vice Chairman, and my esteemed colleagues on the committee. This is SB 440, courts wiretapping misconduct in office. If you stop and think about this proposed measure, you may very well be surprised that this is not already a part of our current law. The discussions bubbling around police accountability have already moved past criminal charges to focus on administrative complaints, but our current law doesn't even allow a wiretap against police for criminal official misconduct. This bill is not about administrative or civil proceedings. It only applies in the criminal context where a warrant is requested from a prosecutor and granted by a judge for an underlying crime of official misconduct. Our law is woefully inadequate, and the debate on police accountability should start here, and we should provide the same threshold for all public officials who swear an oath of office. We should hold our officials accountable under the law. Only we can do this as legislators. The bill does not seek to codify the common law criminal offense of official misconduct. The existing standard is added to the enumerated list of eligible crimes for a warrant to receive a wiretap. These wiretaps are automatically set to sunset unless the need for it to is to reestablished with a judge at the end of the month. There's no indication that wiretaps will be sought or granted for minor infractions, but instead would allow serious investigations where the tip of the iceberg is visible, but the underlying harm may not be yet so apparent. As a common sense measure, SB 440 allows for common sense police accountability and provides increased confidence of the integrity of our elected officials and public officers who similarly swear an oath to uphold the Constitution and to use their entrusted power in a lawfully manner. There is a clarification amendment that this bill would extend to the transmission of the evidence to law enforcement as well as the mere collection of it. Because under current law, not only is recording illegal, but so is the transmission of the audio recording. Therefore, we need clarity and clarification that the transfer to law enforcement would have an exception as well. That amendment has been prepared, but I don't know if it's available yet to the committee or to this very date. But but we're happy to discuss the intent and language, but suggest that those questions about the amendment be addressed to the Office of the State Prosecutor or the state's attorneys who are here in support of this bill. For these reasons, I respectfully request a favorable report with the amendment to allow for the procedural transmission to law enforcement for investigative purposes. And I urge my esteemed colleagues to vote favorable on this bill. And I'll turn it over to my witness. Thank you, Mr. Chairman, Mr. Vice Chairman.
Excellent. Thank you, Senator Lee. And your primary witness today is Ms. David. So Ms. David, you'll have 5 minutes as the primary. The floor is yours.
I'm actually going to yield to Mr. Howard, and then I'll kick in with some of the details after that.
Oh, excellent. My apologies. Hey, Mr. Howard, I didn't even see you there. All right, you're up. My apologies for the confusion, and you'll have 5 minutes. Good to see you.
Well, thank you. We always believe in closing strong, Mr. Chairman, so that's why Ms. David will follow me. But thank you, Mr. Chair and members of the committee. For those that don't know, my name is Chuck Howard. I'm the Maryland State Prosecutor, and I'm here to express our office's strong support for Senate Bill 440, wiretapping misconduct in office, which adds misconduct, as Senator Lee said, in office to the list of enumerated crimes in the Courts and Judicial Proceedings Article 10406, which allows law enforcement and prosecutors to obtain wiretaps to intercept electronic communications. This law arises out of the very real difficulties and challenges faced by law enforcement and prosecutors generally when investigating and attempting to prosecute cases related to official misconduct. As all of you are aware, our office, the State Prosecutor, is an independent agency that is tasked with ensuring the honesty and integrity, specifically of state government and elections and local officials, by conducting thorough independent investigations and when appropriate, prosecutions for criminal conduct, including misconduct by public officials. I believe our office, misconduct in office by a public official, is one of the core crimes we investigate and one of the core crimes we prosecute. And it has been a challenge. It's been a challenge during the past year, during my tenure in office, because of the limit that we face due to the inability to obtain oral wire intercepts for communications. As Senator Lee said, this truly comes out in cases as one prime example for police misconduct. Misconduct in office is a common law crime in Maryland, and our case law is very well settled. It does not apply to a mere mistake or a misjudgment. That you need true evidence of criminal intent, what we in the law call mens rea, of a corrupt motivation proposing the act. There's three kinds of criminal misconduct: malfeasance, misfeasance, and nonfeasance. Malfeasance, where you commit a criminal act. Well, the mens rea is included in that. But misfeasance, where you're creating an act that's otherwise lawful, but you're doing it for a corrupt reason, or nonfeasance, where you're not doing an act that your job would require you to do. Both of those instances of criminal misconduct require clear evidence of corruption and a corrupt intent. And in many cases, we can only get that from the actual communications of the target of the investigation. As Senator Lee mentioned, this does not allow for a rubber stamp for oral wire intercepts like any other oral wire intercept of electronic communication in our statute. You have to comply with the requirements of the Courts of Judicial Proceedings Article Section 10408, which are very detailed. And you have to satisfy a judge as to a number of factors before you can obtain a warrant in this case, or an ex parte order. And Ms. David will go into further detail of that. And finally, to conclude, I just want to add that we strongly support including this reform to our public corruption laws that will allow us to more aggressively, thoroughly, and professionally investigate and, where appropriate, prosecute public misconduct crimes. With that, I'll yield to Ms. David and be available for any questions. Thank you.
Excellent. Thank you, Mr. Howard, and my apologies for mix up again. And so with that, Ms. David, you're up.
Thank you. Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Sarah David, and I'm Deputy State Prosecutor for Office of the State Prosecutor. I know you just heard from Mr. Howard about the importance of Senate Bill 440. I just want to talk for a few minutes about the functional aspects of this legislation. I know that this committee hears a lot about, the notion of wiretap, but it's important to note that there are different facets of the wiretap law. and that this legislation is modifying what is 10406, which is a wiretap investigation that involves an extensive application to a judge. In the interest of time, I'm just going to outline some of the basic requirements. I'm happy to go into more detail if there are questions. We have to identify, the investigator or the prosecutor has to identify in writing who the law enforcement officer is making the application to a judge. There has to be a full and complete statement of facts that includes details about the offense, the location and nature of the place that's being intercepted, and the types of communication that are being intercepted. There's also this concept of exhaustion. And exhaustion is a full and complete statement that the investigator has to attest to as to whether or not other investigative procedures have been tried or failed, or why they reasonably appear unlikely to succeed, or why they would be too dangerous. There also is a statement for the period of time required that this would be maintained. So the wire can only be maintained for 30 days without a new application to the court. And the period of the extension, though, should be no longer than the authorizing judge deems necessary. So while 30 days is the maximum of each time, a judge could say, okay, you only need 7 more days to complete this investigation based on the information I have. And whenever an order authorizing an interception is entered pursuant to this law, the order shall require that reports are made to the judge who are issuing the order, showing the progress toward the achievement. So again, this isn't just, this is actual writing that you have to present to the judge to show that you're actually making progress in your investigation. And this allows for investigations of networks where other more traditional means of investigation, as I said, have been exhausted. This isn't merely the ability to decide on the basis of an allegation to listen to somebody's calls. This is an essential tool in rooting out corrupt networks, especially in organizations that can be hard to penetrate with interviews and investigative tools. Thank you for your attention, and I'm here for any questions on this issue and hope that you'll issue a favorable report on this legislation.
Thank you, Ms. David. Next up, we have Mr. Schellenberger. Good to see you. Good afternoon.
Good to see you all. I guess I could just say ditto because you had the right folks go, and I guess since I'm going after Ms. David, we decided to finish weak instead of strong. But as we all know, Maryland is a two-party consent state, and that is two parties must consent in order to record a conversation, particularly on a phone. The wiretap statute was specifically designed that when investigating certain crimes, the state's attorney can go to a judge under their supervision and obtain a order for a wiretap. One of the things that's very important to know is this is one of the few things that is actually required of the state's attorney or Mr. Howard and the state prosecutor. This is something we don't push off on our assistants. To follow up on what Ms. David said, to show you how extensive these applications are, they typically come in a big binder. These are not 1 or 2 page requests. These are very serious requests that I, as the elected state's attorney, have to sign, and I, as the state's attorney, have to take an oath that everything in that statement is true. So this is taken very seriously, and as everyone said, there are time limitations on it. Maryland has for years had 22 exceptions to what's called two-party consent, and that's what the wiretap statute is. And what we are doing here today, both as the state prosecutor and as all the local prosecutors are asking, is let's add one more crime, and that's misconduct in office. And gee, doesn't that make sense? I mean, misconduct in office is clearly a crime that is conducted surreptitiously. And so it makes perfect sense that the wiretap statute should be expanded to include misconduct in office. This is a very logical extension. And if you look at CJ 10406, there are lots of limitations on how this is done, and it's not done just willy-nilly. So we believe this is a good addition.
Excellent. With that, it looks like that concludes the testimony for Senate Bill 440. We'll now turn it over to the committee for questions. We've got 2, Senator Heddleman and then Senator Sidnor. Senator Heddleman, you're up.
Thank you very much, Mr. Chairman, and thank you. This seems like a very worthy cause. I just have a quick question for Ms. David. I think you mentioned that these are 30-day warrants. I assume these are, as Mr. Schellenberger just said, kind of long, in-depth, well-researched asks. What happens at the end of 30 days? You just go, you show your progress, you go before the judge, you ask for an extension?
So it's 30 days at a time is the maximum at a time. It can also be less. It can also be 7 days, 3 days, 2 days. I mean, you can do it for whatever period. It's 30 days at a time. That's the maximum time. And then you have to defend why it would need to be extended.
Okay, thank you.
Excellent. Thank you, Senator Sidor.
Thank you. And good afternoon. Ms. David, you had mentioned that there were, I think you said 4 types of did you say 4 types of wiretaps?
I didn't. I said there were different aspects of the wiretap statute.
Okay.
And this is addressing a specific type of wiretap.
Okay. Then, and this is where you all could help me, because I can remember following some of the cases where former colleagues of mine were prosecuted, and I remember reading verbatim some quotes that were in the paper. I'm assuming, if you can talk about it, were these not wiretaps? These were some other ways that you all got verbatim conversations? And I'm asking because I'm trying to understand what capabilities you currently have that to get at I guess the kind of conversations that you all are saying that you're unable to right now without the statute.
So Senator Cinder, I'm happy to kind of talk to you offline if you have those exact examples. I'm happy to kind of talk about them. I'm not familiar with the exact quotes you're talking about. This would be what is kind of real time. This is actually a rather personnel intensive operation where you're listening to people as they're communicating. So this would be, there are other ways. So for example, if you did a search warrant on somebody's cellular phone and you were able to see prior or past conversations, that's a way you could obtain those types of things. This is an investigative mechanism to look at networks that are in current operation and to look at what they're doing now. I'm happy to address kind of the specific quotes offline with you, at any time. But this is not something that we can currently do for misconduct in office. Importantly, though, if we're investigating other types of offenses, such as bribery, we would be able to use this. But we would have to show the judge that we have probable cause of a bribery, as opposed to misconduct in office, which doesn't necessarily extend to a lot of the behaviors that would be encompassed, especially in law enforcement networks, if that's helpful.
All right. And then that's probably what was being investigated. Thank you.
Thank you, Senator Sidor. Senator Castley has a question.
Thank you, Mr. Chairman. I guess this is me. I just start with Mr. Schellenberger, if that's okay. Thanks for spending more time with us. I tried to lower my hand, Mr. Chairman, but I don't know. It won't go down. So I'm like the permanent.
True to form,
There it goes. There it goes. So, so I'm looking at the bill right here, and it gives just more of a bigger picture thing. State's attorney, the attorney general, state prosecutor, state attorney can all apply for wiretaps, but for things like murder, kidnapping, and rape. But only the attorney general, only the prosecutors, county prosecutors investigate murder, kidnapping, and rape, right? So is there something else that says that, do we have the attorney general and the state prosecutor going around seeking wiretaps for those events as well?
Well, I would say it's unlikely, but I'd also say it's not out of the realm of possibility. So there are times where my office may have a conflict in a case. Perhaps someone in my office was a witness to a murder or a robbery. I may ask one of my fellow prosecutors in, say, Harford County or Baltimore City to handle the case in my jurisdiction. But if the witness was somebody who was well known to a lot of prosecutors, which very often happens, I may turn to Mr. Howard or Ms. David and say, can you handle this case? Because I have a conflict and so does another office. For instance, if the witness had previously worked in, say, the city state's attorney's office or in Harford County. So there are times where we have to turn to others for assistance for even those type of crimes. I do admit that more likely than not, the state prosecutor is going to investigate misconduct in office, but I'm here supporting them because I think this is a very important addition.
Right. So this putting this in here doesn't expand anybody's jurisdiction. I mean, I don't think the state prosecutor has the authority to just go in and start coming to Harford County and start charging rape that doesn't involve I guess it was misconduct in office if you did it in your office, but for just a normal citizen, this doesn't expand their jurisdiction, right?
No, we're not expanding the jurisdiction at all. All we're doing is adding a charge to the 21 exceptions that allow us to go to a judge and plead for a wiretap. And just to expand on what Ms. David said, not only does it only last 30 days, we got to go back and ask for an extension if we want to go longer. And every 7 days, every week, those detectives report to the judge on the progress they've made. Very, very hands-on with the judges, more than in any other area of the law when it comes to investigations.
And then when I look at the other, there's 22 other offenses here that we can get a wiretap on. And most of them actually cite the section of the criminal law article, with the exception of things like bribery and extortion, which I guess are just common law. But misconduct in office, is that actually a crime? I mean, and I know you can charge somebody with misconduct in office, but is that sort of a catch-all term, or are there actually elements of a crime of misconduct in office?
I will defer to Ms. David on that, since she and Mr. Howard often do this crime.
Okay.
Yeah, there are actually elements of that offense, Senator. And so I believe that Mr. Howard alluded to them, but it's that the individual has to be a public official, and then there's the corrupt intent element, and it has to be in the course of their office. And then, as I think Mr. Howard alluded to, there's the misfeasance, nonfeasance, and malfeasance. So it's an actual crime, and just like, you know, extortion or bribery derived.
Well, it's a common law crime. There's definitions of it. I can pull it up, and there's elements of the crime of misconduct in office.
And I can send you the jury instructions if that would be helpful. I can send that.
I trust you.
Okay.
I'm not gonna get that deep in the weeds. But then, now, I mean, misconduct in office could, as I understand it, that's any kind of police. This isn't just this isn't just elected officials. It's not like senators and all that. This is anybody who holds a public office, which would mean any a police officer, anybody who takes an oath of office. It would include all of them, right?
It would include police officers, yes.
Okay.
And Senator, I'll remind you of the Gun Trace Task Force. You know, that would be the kind of place that would be perfect for this type of expansion of the crimes, not the way we do it, but of the crimes that could be included.
Okay. Okay. Thank you, ladies and gentlemen. I appreciate it. Thanks for your answer.
Excellent. Thank you, Senator Casserly. Looking around the room and ensuring I don't forget anyone. Seeing no further questions, that looks like that concludes the hearing for Senate Bill 440. Thank you all very much, Mr. Schellenberger, Mr. David, and Mr. Howard. Good to see you. Go Navy, and we'll see you all soon. All right. Next, we have Senator West. Is Senator West up? And he may be, oh, here you go, here you go. I know you're a busy man, so I don't want to interrupt you.
Actually, I was eating a sandwich.
Oh, okay. Do you want us to, are you okay, or are you?
I'm fine.
Okay, great. Okay.
Actually, I thought there was another bill ahead of me, but I'm happy to go.
Okay, great. So we'll do Senator West with Senate Bill 443. The floor is yours.
Thank you very much, Mr. Chair. I'm pleased to introduce Senate Bill 443. This bill is a response to innumerable cases this past year in which mobs of citizens attacked public monuments, toppled them, and in many cases destroyed them. For purpose of this bill, I'm willing to accept that many members of these crowds had read their history, had studied the lives of the figures portrayed in stone or bronze, and had concluded that such persons were undeserving of memorialization in a prominent public place. In some cases, I'm willing to acknowledge sympathy with the strong feelings motivating the crowd to want to eliminate the statues from further public viewing. But there's an old adage that people are not entitled to take the law into their own hands. A person may commit a heinous crime, but we don't permit a crowd of angry people to murder the culprit. Someone may have stolen valuable property, but we don't permit the owner of the property to subject the thief to grievous bodily harm. The same rule must apply across the board. Taking the law into your own hands, lashing out and injuring fellow citizens or destroying property can't be tolerated. We are a nation of laws. It is for this reason that the FBI and other law enforcement agencies are bending every effort to identify, arrest, indict, and ultimately prosecute the people who broke into the U.S. Capitol building on January 6th and caused numerous deaths and substantial destruction of property. We are a divided nation, but that does not justify lawlessness or the wanton destruction of property, whether private or public. Here in Maryland in recent years, we have seen a groundswell of objections to the continued presence of certain public monuments in prominent locations. This started several years ago when some people became indignant that the statue of Maryland's only Chief Justice of the U.S. Supreme Court sat on the grounds of the Maryland State House. Responding to the strong views of those citizens, the governor, the Speaker of the House, and the President of the Senate used the powers vested in them to cause the statue of Roger Brooke Tawney to be removed and stored in a safe location. At about the same time, some people in Baltimore City became upset that 4 statues erected following the Civil War honoring Confederate heroes continued to stand in prominent locations in Baltimore City. Responding to the strong views of those citizens, the mayor of Baltimore, exercising the powers vested in her, arranged for all 4 statues to be removed and stored in a safe location. One night last summer, however, a mob descended upon the statue that had been erected in the Little Italy neighborhood of Christopher Columbus. They attacked the statue, toppled it, broke it into pieces, and threw the debris into the Inner Harbor. Members of the Baltimore City Police Department stood silently by, observing the mob and the destruction of the statue, and did nothing to either prevent the statue's destruction or to arrest the people responsible. The Columbus statue had been paid for by private subscription, largely from the city's Italian-American community. It was sculpted in Italy, made of Italian marble. It cost $500,000. Many of those who had worked so hard for the statue's creation and erection and who had attended its dedication are very much still alive and were appalled and furious that it had been destroyed. To this day, I'm unaware that anyone responsible for the destruction of the statue has been arrested or in any way held to account. Senate Bill 443 is intended to make it perfectly clear that the destruction of public monuments in Maryland is a crime. It applies to monuments, memorials, and statues which have been dedicated or are maintained by the state or by a local government, and it states that it is a crime to willfully and maliciously destroy, damage, vandalize, or desecrate such a public monument, memorial, or statue. It further provides that a person who causes damage of at least $1,000 to such property is guilty of a misdemeanor, and that the penalty for such a crime will be a fine of up to $2,500 or a jail term of between 1 and 10 years or both. Damage of less than $1,000 would result in lesser penalties. Let me draw a special note to the fact that if this bill should be passed, a court will have the power to simply impose a fine and no jail term for a violation of the law. This will give a court discretion to tailor the punishment to fit the crime. There's no question that statues and other monuments erected in the past do not have some sort of inalienable right to continue to sit in prominent public view. Times change, attitudes change, history is reevaluated. But in passing Senate Bill 443, we will make it abundantly clear that in this state, it is illegal to take the law into your own hands and attack, damage, or destroy public property. There are legal ways to effectuate change. We do it every day here in the Maryland General Assembly. Our county and municipal governments at all levels also do it every day. Our elected officials are available 365 days a year to listen to citizen complaints and act upon them. There's no excuse for public lawlessness. And for these reasons, I request a favorable report on Senate Bill 443.
Excellent. Thank you very much. And so with that, we'll move on to your panel. And is your primary witness, is Mr. Martin in the room? I don't see Mr. Martin. So we'll go on. So Mr. Klima, I hope I pronounced that correctly. You're up next.
Thank you very much. Good morning, Senators. I appreciate this opportunity to speak in favor of Senate Bill 443, a bill intended to prohibit the malicious destruction of historically significant monuments. Sadly, throughout Maryland and the United States, there has been a proliferation of monuments being vandalized or destroyed. Maryland's collection of monuments is diverse and represents a broad cross-section of subjects, time periods, and historical events, each in some way culturally, aesthetically, or historically unique and significant. In addition to monuments honoring the sacrifice of our military veterans, there are monuments to historical figures, civil rights leaders, musicians, poets, religious figures, educators, sports legends, and even a monument to Baltimore's Harris Glenn Milstead, who achieved fame as divine, playing the role of Edna Turnblad in John Waters' Hairspray. Many of the monuments displayed throughout Baltimore City and Maryland's 23 counties were sculpted by world-renowned sculptors, such as Laura Garden Frazier, whose double equestrian statue is considered one of the finest in the world, Hans Schuler, who sculpted the monuments to Casimir Pulaski and Martin Luther, as well as William Henry Reinhardt, whose works are displayed in the U.S. Capitol. Such works are irreplaceable and cannot be duplicated if destroyed. The state of Maryland clearly recognizes the importance of protecting and preserving our historical and cultural heritage, as evidenced by the establishment of the Maryland Military Monument Commission and the Maryland Historical Trust. Baltimore was once proudly referred to as the Monumental City and had the distinction of being the first municipality in the United States to design a comprehensive program for the preservation of its outdoor monuments. It is fitting that Senate Bill 443 support the continued preservation of monuments in Baltimore and throughout the state. Incidents of monument vandalism and destruction are becoming all too common. Sadly, a 225-year-old obelisk monument to Christopher Columbus, said to be the oldest monument to the Italian explorer in the world, was vandalized and suffered irreparable damage. A monument to Francis Scott Key was vandalized, as was a monument to Revolutionary War hero Casimir Pulaski. The Star-Spangled Banner Centennial Monument, donated by children of the Baltimore City Public School System, was vandalized, as was the Fallen Heroes Monument to Baltimore City police officers killed in the line of duty. And recently, most of us will recall a monument of Christopher Columbus being toppled and tossed into Baltimore's Inner Harbor. Destruction and vandalism to monuments is disturbing on a number of fronts, particularly from a public safety perspective. There was a recent incident in Virginia where a large portion of a monument fell on an individual trying to topple it, nearly costing the individual his life. The clear sentencing guidelines and penalties provided for in Senate Bill 443 will hopefully serve as a deterrent to individuals contemplating the malicious destruction of Maryland's historically significant monuments. The clearly articulated minimum mandatory sentences and fines upon conviction establishes that unlawful actions have consequences. For these reasons, I encourage your favorable support of the bill. Thank you.
Excellent. Thank you very much. And next we have Mr. McAvoy. Are you here? There you are.
Yes, thank you so much, committee. And Senator West, thank you for bringing this bill. I appreciate the way that it was written. You know, a dog understands property rights. And that's what the essence of this bill is. In Philadelphia, when there was a statue that was being threatened to be taken down, people actually camped out all night. We simply cannot do that for all of public property issues. That's just not how we operate as a civilized society. And so progressing forward in that realm is just not acceptable. So I like this bill. The one thought that I had as I'm looking at it, 6301.1, in C, it mentions that the person causing violation. And I would add that it seems like officers were apparently told to stand down. Somebody told them to stand down. And There was also conjecture you see on social media where various elected officials were involved or added fuel to the flames on this issue. And I would like to see that type of thing was also maybe more strictly fleshed out in the bill. Because when you look at the videos of who did it, they're largely children. I mean, these are college-age kids. And I don't know that they all had researched. I guess we give them the benefit of the doubt. I don't know that all researched all the history of our country and what was going on over the various centuries that we've forged the land out of wilderness. So I thank you again for bringing the bill. I think it must pass, and I think that any civil nation, we simply have to respect these property issues and the rule of law. And honestly, the thing that happened in Baltimore, in my city, what if they had just moved it, right? They didn't want it there. I know that where they show those movies, right, in Little Italy on Friday, well, they used to on Fridays, they could have put it right there, out of everybody's way. And I just think a more realistic and civilized approach is in order. Thank you for bringing the bill.
Excellent. Thank you for your testimony. And Senator West, I'm looking around for Mr. Martin, and I don't think Martin is here. So with that, that will conclude the testimony for Senate Bill 443. And I'll turn it over to the committee for questions. Seeing none. Senator West. Sorry, I'm trying to unmute you here. Here you go.
Thank you, Mr. Chair. I just wanted to say, this is a cross file of a bill in the House. And if I had drafted it, I would have had some reservations about including the mandatory minimum provision. So if the committee wants to work its magic on the bill in terms of the mandatory minimums, you'll get no objection from me.
Excellent. Thank you. Okay. All right. With that, that'll conclude the hearing for Senate Bill 443. We'll now move on to Senator Casserly, who has the next two bills. Senator Casserly will start off with Senate Bill 383. Senator Casserly, ready to go? Or
yeah, that's fine. Thank you, Chairman.
Excellent.
Thank you. I've got some really good witness panels on this one. Senate Bill 383, court order to use cell site simulator, obtain location information from electronic device. I'm just going to go ahead and introduce the primary witness, State's Attorney for Baltimore County, Mr. Scott Schellenberger. And he'll be followed up by Steve Kroll with the Attorney's Coordinating Office. Thank you.
Excellent.
Thank you, Senator Casserly, members of the committee. I'm here in support of Senate Bill 383, which is a easy fix to a little loophole in the law that's been around for a little bit of time. So a couple years ago, we were all before you dealing with the issue of cell site simulators and how we get cell site location information. And we dealt then with the substance of the law on what kind of court order was needed to get this. So here today, we're just asking for a simple cleanup. And that is, in that law, we did not explicitly state that these orders can be obtained electronically. There are some counties who are doing it because the judges are accepting an electronic court order. There are other counties who are not doing it because of that very reason. It's not in the statute. So what we did was we went back to the search warrant statute that precedes this one. So we're asking you today to fix section 1203.1, dealing with location information in criminal procedure, and making it look exactly like 1-203. 1203 we fixed several years ago, allowing search warrants from police to be sent to a judge electronically. And actually, it lists three ways. It can be done in person, which is how it was done for decades. It can be done by fax, and it was done that way for many, many years. And then we realized it could be done electronically. And so we fixed the part of 1-203 dealing with search warrants, and now we're asking that we fix it with regard to 1-203.1 so that these statutes look exactly the same, one dealing with search warrants and one dealing with location information. Many of the counties have a laptop computer that goes to the on-duty judge, who then takes it home and receives these orders all through the weekend and unfortunately all through the night, so that they can sign them electronically. So we're just trying to standardize the law and standardize the practice. It's not changing the substance, it's merely changing how the communication takes place. And therefore we urge a favorable report for Senate Bill 383.
Excellent. Thank you very much. And with that, we'll move on to Mr. Kroll. You're up. Good to see you.
Mr. Chairman, good afternoon, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. And I'm here in support of Senate Bill 383 and ask for a favorable report. And I agree with everything Mr. Schellenberger said. And ask for a favorable report again as Senate Bill 383. Thank you.
Excellent. There you go. All right. With that, that concludes the testimony for Senate Bill 383. We'll turn it over to the committee for questions. Senator Cassidy, you want to go first, or you?
I would just say,
sorry, good.
On that one, I don't know if there's any questions, but I guess Senator Sidnor does have a question, so I don't have a question. Go ahead.
Okay, got it. Great. Excellent. Senator Sidnor, you're up.
Thank you, appreciate it. And good afternoon. I see Mr. Kroll just smiling at me. What now? Just to help me, what has transpired since we passed this last year between now and that brought this issue forth?
So what happened, Senator, was we passed the way and what the police and the state are allowed to do when it comes to getting the cell site simulator, and that was part of your bill, and then also the location information. So the way we do it by getting a court order is not being changed. The only thing, and I guess I'm using a bad word by saying way, the only thing that we're doing is we're clarifying that these orders can be obtained in person, so at the judge's chambers or at the judge's house, by fax, and those two things have been around for decades. What we're adding now is the same provision that's in the search warrant proceedings, which allows it to be done electronically. So if you're an officer or detective in Woodlawn and you need location information on a phone, you will electronically send that to the judge in Parkton. The judge can read it, and does read it and signs it electronically and sends the court order back to the detective, which then allows them to go to AT&T or Sprint or whoever and obtain the information. So we're still requiring a court order. We're still requiring everything to be under oath. The judge has to sign, can or cannot sign it. It's up to them. But once they sign it, all this can be done electronically. We're just trying to bring ourselves into this century, let alone this decade. And that's the way all of us communicate. I send all my written testimony down electronically, and there's no reason why these can't go back and forth electronically. And like I said, the judges in almost every jurisdiction have a dedicated computer with secure internet that they use to sign these.
Thank you.
Excellent. All right. Thank you, Senator Sidnor. Looking around, see no further questions. Thank you, Senator Cassidy, Mr. Schellenberger,
Thank you.
and Mr. Kroll.
Thank you, colleagues. Appreciate it. Thank you, gentlemen, for appearing.
Excellent. With that, that concludes the testimony for Senate Bill 383. We'll now move on to Senate Bill 385, Senator Cassidy.
Thank you, Mr. Chairman and colleagues. This bill passed out of this committee, the same bill passed out of this committee last year and cleared the Senate. Unfortunately, the House didn't have time to finish this up, so it died. This is our bill on organized retail theft. I've got two excellent witnesses here for you. My primary one is Kaylee Locklear, and then we also have Detective Matt Vendemio. So I'd like to go ahead and let Kaylee Locklear tee it off, Mr. Chairman.
There you go. Ms. Locklear, the floor is yours. Good to see you.
Good to see you as well, Mr. Chairman and honorable members of the Judicial Proceedings Committee. I'm here on behalf of the Maryland Retailers Association in strong support of this legislation. It's taken us a couple years to get to this point. Our bill is merely clarifying allowing theft to be aggregated across jurisdictions that occurs under one scheme or a course of conduct. A scheme or course of conduct is already allowed to be used in one county. So to clarify, this bill is only going to apply to situations where someone has repeatedly stolen over a course of time, maybe from the same individuals or parties and over a course of weeks or months. If that is the case, then the state can charge the person under a continuing course of conduct and aggregate theft. We did talk to the Attorney General's office about this, who believe that we are merely clarifying the law because they've actually already aggregated theft in some larger cases at the state level. And I just want to say to the committee, petty theft then is completely untouched by this bill. We talked about that for years. Organized retail crime continues to grow every year, helping to fund gang activity, professional theft rings, domestic and international crime rings, and it costs retailers more than $40 billion each year. But the cost is not just felt by retailers. There is lost sales tax revenue, higher prices for consumers, and probably most importantly, a health and safety aspect. In many cases, stolen food products, pharmaceuticals, and other consumables are not maintained under proper conditions when they're stolen or even labeled properly. So when they do finally make their way back to unsuspecting consumers through illegal distribution channels, they may be ineffective, or even worse, they may make people sick. Last year, I talked about baby infant formula and over-the-counter drugs as examples. So thank you to those of you who have met with me over the years to discuss this very important bill. I'm glad to answer any questions the committee may have. Thank you.
Excellent. Thank you very much. And with that, Mr. Vendemino is up next.
Hello, hi, my name is Detective Matt Vendemio of Montgomery County, Maryland Police. We're going to the Wheaton District. I investigate a lot of these organized retail crime groups, and I'm very interested in this. They travel up and down the 95 corridor from Florida to New York, Connecticut, things like that. We get a lot of European suspects coming over, and South American suspects. These guys are not just going in and stealing a belt or shoes. These guys are going in and stealing everything and anything off the tables. They sell these to fences, where the fences make a lot of money on this, and it pretty much hurts everyone in the long end. You and I have to pay more for these products.
Excellent. Thank you very much for your testimony.
Welcome.
I think we're having some technical troubles. Am I the only one that cannot hear?
Here.
Okay.
I'm good.
You good? Okay, great. Excellent. Thank you very much. All right. With that, that concludes the testimony for Senate Bill 385. We'll just turn it over to the committee for questions. Seeing none. That'll conclude the hearing for Senate Bill 385. Thank you, Senator Castley.
Thank you, Mr. Chairman and colleagues.
Excellent. Thank you. All right, now we'll move on to Senator Heddleman, Senate Bill 505. Senator Heddleman, you're up.
Thank you very much, Mr. Chairman, Mr. Vice Chair, members of the committee. I am here to present Senate Bill 505, and I suppose it is appropriate to follow the hearing that we just had, because we're going to talk about continuing course of conduct once again, but in a different context. This bill is also, I think, pretty straightforward, and it is meant to close what I hope was an unintended loophole in our law. This bill serves to protect children who have been victims of continued abuse by parents, family members, guardians, or others that have permanent or temporary care, custody, and supervision of a minor. It clarifies that it is a violation of the state's prohibition on first-degree child abuse to engage in a continuing course of conduct that includes 3 or more acts of second-degree child abuse. Medical professionals today often diagnose a child as a victim of torture based on their numerous injuries that have occurred over a period of time. But our current law says that they are only able to be charged with separate offenses of second-degree child abuse, which under our law is not considered to be a crime of violence. This law closes this loophole between medical diagnosis and the criminal law. There is already a law on the books requiring this continuing course of abuse when it comes to sexual abuse of a minor. And we would expect and hope that physical abuse of a minor be treated in the same way. You're going to hear about real life circumstances that some of the prosecutors who are on my panel are dealing with, so that I hope it will be brought to light what a real and current problem this is. So without further ado, I ask for your support of Senate Bill 505 and turn it over to my panel. Thank you.
Excellent. Thank you, Senator Heddleman. And your primary witness is Ms. Marsh. So Ms. Marsh, you're up next. You'll have 5 minutes.
Thank you, Your Honor. Thank you, Mr. Chair. So used to Your Honor still. Members of the committee, my name is Catherine Marsh, and I'm the Special Counsel and the Assistant Chief of the Special Victims Unit for the Prince George's County State's Attorney's Office. I'm here today on behalf of State's Attorney Aisha Braveboy, my entire unit, and the Maryland State's Attorneys Association in urging a favorable report for Senate Bill 505. The best way to explain the importance of this legislation is to describe 2 cases our unit recently handled where the law has failed. One involves an amazing young lawyer who was dropped off at the hospital when he was 2 years old. He was diagnosed as a victim of repeated child abuse. His body had circular burn marks later discovered to be caused by a taser, a chemical burn consistent with having bleach poured on him, and healing whip marks from an electrical cord that occurred over different time periods. Through the investigation, it was discovered that in addition to the outward physical signs of abuse, he was also repeatedly waterboarded by being plunged under icy cold bath water whenever he annoyed the caregiver. It was years before this young lawyer could even be in a bathroom that contained a tub. He's now 5. He's diagnosed with severe PTSD and cognitive delays due to the repeated abuse he suffered from the age of 9 months until the age of 2. Another case involves an 18-month-old girl who arrived at Children's National Medical Center. While there, the doctors discovered 18 different bite marks that had broken the skin from 2 different adults, numerous fractures, as well as burns to her hands. All of these injuries occurred within days and weeks of each other. The medical diagnosis in this case was torture. However, under the current law in Maryland, the evidence in both of these cases was not enough to charge first-degree child abuse. Because although the medical diagnosis was torture or repeated child abuse, the doctors could not say that any single injury involved an injury to the brain, starvation, substantial risk of death, disfigurement, or impairment of an organ. This left only the charge of second-degree child abuse, which, as you heard, is not a crime of violence in Maryland. These are just 2 examples. We have numerous cases involving multiple fractures and continued beatings and whippings. Being told that continued abuse against them is not a crime of violence and the acts of abuse do not carry significant sentencing guidelines reinforces the idea that this type of abuse is permitted or at least not taken seriously by the criminal justice system. Our current law fails to protect our most vulnerable victims, and we lag behind many states who recognize continued abuse, fractures, burns, and more for a heightened felony. The state of Maryland has already recognized the seriousness of a continuing course of abuse when it comes to sexual abuse and has for decades. We are asking for the same consideration and support for children who suffer from physical abuse and urge a favorable report of Senate Bill 505.
Excellent. Thank you very much, Ms. Marsh. We'll now just go in order. Mr. Schellenberger, you're up next.
Thank you so much, Mr. Chair. Thank you, members of the committee. I'll be very brief because you have some great subject matter in the trenches prosecutors on this particular panel. I support Senate Bill 505. It's another place where we've been missing something that should seem obvious to all of us. Very often when we charge child abuse, we'll charge a wide range of dates because different incidents happen over a period of time, but it may take that wide range of dates to add up to a continuing course of conduct and thus perhaps severe child abuse. And that's what can lead to the severe injury. What we're trying to do now is say, if you got 3 of those, then you need to be subject to the higher penalty and punishment. And that only makes logical sense. And I think Ms. Marsh and the other prosecutors on here have unfortunately actually bad in the trenches examples of this. And I strongly support Senate Bill 505. Thank you, Senator Heldman, for finding this hole in our law.
Excellent. Thank you, Mr. Schellenberger. And next we'll have Ms. Feinstein. Hey, Debbie, there you are.
Thank you so much. Good afternoon. My name is Debbie Feinstein. I am the Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. Thank you, Mr. Chair and Mr. Vice Chair and members of the committee. I concur with my colleagues, Mr. Schellenberger and with Ms. Marsh, and want to add a couple of other comments and an example from Montgomery County. As Ms. Marsh described, in Montgomery County, we see similar situations where we have of child abuse that happen over a period of time or even in quick succession to one another, where we can only charge second-degree child abuse. I can give you an example of a 5-month-old child that had multiple fractures, something called a classic metaphyseal fracture in his humerus, in his radius, on one arm, additional fractures, supracondylar and lateral fractures on his other humerus, another classic metaphyseal fracture in his humerus. I say all these words because these are the words that we're using when we go to court, and they're specifically indicative of child abuse, that we know that these are not accidental injuries. They require yanking, pulling, jerking on this 5-month-old child, repeated acts of child abuse. Each individual act is a second-degree child abuse. Together, they should be a first-degree child abuse as delineated under the proposed law described in Senate Bill 505. I would also note that many other states, as Ms. Marsh alluded to, include child torture or continuing course of conduct as aggravated felonies. I mean, their laws don't necessarily look exactly like ours, but as their aggravated or top felony. Just to give you a few examples, Florida, Delaware, Tennessee. I know that Ms. Marsh has put together or is putting together a more comprehensive list so that members of the committee can see where we are lagging behind and how we are lagging behind. I would urge this committee to issue a favorable report on Senate Bill 505, and I thank you for your time today.
Excellent. Thank you very much. Good to see you. Next, we will have Ms. Cordero. You're up.
Good afternoon, Mr. Chairman, members of the committee. My name is Rebecca Cordero, and I'm an assistant state's attorney for Calvert County. I have been a prosecutor for 17 years, and I handle child abuse and sexual assault cases. I am here today to testify for Senate Bill 505 and ask for a favorable report. As you heard from Ms. Marsh and Ms. Feinstein, the bill adds a continuing course provision to the elements of first-degree child abuse. I have, during the course of my career, seen several cases of severe and repeated abuse of children that do not rise to the level of first-degree child abuse, but are nonetheless horrific and tragic. One case in particular involved a 7-year-old boy who had never had his father be a part of his life. And when he was 7, his father asked to pick him up and take care of him for a couple of weeks. And his mom obliged because she was a single mother who needed the help. And during the 3-week stay with his father, the 7-year-old was repeatedly burned with cigarettes, beaten with electrical cords, and abused at his father's hands. Each of those injuries standing alone would only constitute a second-degree child abuse. However, when he was returned to his mother, she noticed a difference in him, and he wouldn't talk. He had bruises all over him, burn marks, and but still those injuries alone, standing alone, only constituted several different third or second degree child abuse charges. So this bill, if passed, would have allowed us to charge him with first degree child abuse. It's especially important because second degree child abuse is not considered a crime of violence, and any sentence is eligible for parole after 25% of the sentence is served. The offender of the 7-year-old juvenile received the maximum sentence for 15 years for his abuse of the child. However, he'll be eligible for parole after 4 years. Child abuse is a public health crisis. The CDC reports that approximately 1 in 7 children were abused in the past year. Children who are abused suffer physical injuries as well as emotional and psychological problems. Exposure to violence in childhood increases the risks of permanent injury, future victimization and perpetration, substance abuse, delayed brain development, lower educational attainment, and limited employment opportunities.
You can briefly conclude. Sorry, we don't have a timer on this application, so you get the voice of God every now and then. So our apologies for that. But
I'm almost done. I was just going to say this bill supports tougher penalties for those who harm children. It is our duty to protect those children. As a prosecutor who constantly sees abused children, I am asking that you submit a favorable report to this bill.
excellent. Thank you very much. And again, apologies for that. The voice of God telling you your time is up. All right. Looking around, I see that concludes the testimony. We'll now turn it over to the committee for questions. I see Senator Sidnor has a question.
Thank you, sir. I had a question looking at the language on line 17, 3 or more acts, and then listening to most of your testimony, I'm curious, is it your interpretation of the bill that maybe, I think someone mentioned a child being burned by cigarettes or having multiple cigarette burns? Would each of those cigarette burns count as an act? Or are we talking about 3 different discrete occasions? Or I mean, what is your interpretation on how this would be used?
So typically the law for an act, it's a different event. And anything that occurs within the one event is one act. So for this, it would have to be 3 separate and distinct events of abuse. It mirrors off of the continuing course of sexual abuse, which requires 3 separate and distinct acts. So even if in the one event there were several forms of abuse, we would still need another 2 events.
And which then leads to my next question. Why 3? I mean, why not?
And it strictly mirrors the continuing course of sexual abuse of a minor.
Okay, thank you.
We can go with 2, Senator, if you'd like.
I don't mind. Thank you.
All right, excellent.
Mr. Chairman, if there are no more questions, I'd just like to, one thing, just acknowledge State's Attorney Braveboy for bringing this important issue forward. So I want to thank her publicly.
Great, thank you. Continues to do great work. Awesome. Looking around the room, I don't see no further questions. That'll conclude the hearing for Senate Bill 505. Thank you, Senator Hedelman, and thank you all the panelists.
Thank you.
We'll now move on to Sandy. I'll rely on you here. Is Senator Carter here? And if not, I know she may be in other committees testifying. If not, we'll just jump down to my bill.
She's in finance.
She's in finance. Okay, great. So then we're now going to take Senate Bill 479. Are all the witnesses available? Okay, great. I see a couple folks are fluttering in. So for the record, Senator Smith here to present Senate Bill 479. We've seen a substantially similar bill that passed out of this committee and then passed off of the Senate floor, I think the last day of session before we concluded because of COVID. And essentially, I'm just going to walk through the bill, but this bill has been before us for several reasons. It essentially requires and puts in place some pretty common sense requirements to ensure that people throughout Maryland safely store their firearms. We've got some Maryland specific numbers. I don't want to belabor the point of going into the specific vignettes and stories because we have some witnesses that'll come behind me to explain that and talk and speak to how this gap in the law has personally affected them. But some of the numbers, the Maryland specific numbers, 3 cases involving children under the age of 11 happened in just 2020, just last year. Last year, I gave you some numbers from 2019. It said under the current law, for an offense relating to providing access to firearms by a child, there were over 150 violations reported in the district and circuit courts. That's under the current regime. So again, I said this is substantially similar to last year. I'm going to walk you through the bill very quickly, and then I'll turn it over to the panelists. The meat starts on page 2, it changes again, just like last year. Child changes the definition from child from 16 to 18. And if you move farther down, there are a couple of exceptions that apply. So you have to safely secure your firearm, and the child that has access to it is either 18 or below. And the exceptions are that the firearm was obtained as a result of an unlawful entry. The access to the firearm was supervised by an individual who was at least 18 years old, so by an adult. A couple of other exceptions. If the child has a certificate, a hunter safety certificate, and they're also accompanied by an 18-year-old, they've been given express permission by the minor's parent or guardian to access the rifle or shotgun for the purpose of engaging in a lawful activity. And so that's basically the first chunk of the bill. The second chunk deals with basically the mechanisms of how it has to be stored. So it has to be stored, the firearm has to be unloaded, and any ammunition that the person owns or controls that is suitable for the use in that firearm has to be separate and secured in a secure location where the minor could not reasonably gain access to the ammunition. And that's on still on page 2, lines 25 through 27. If the firearm is left or stored and unloaded, it has been rendered inoperable. So if it's inoperable, it's like for a gun lock or trigger lock rather, that would be considered inoperable. Now, I know that some questions have come up that may indicate the Heller decision, and I know we got an Attorney General's opinion last session that addressed that, but we can have that discussion later on as well. A person may not leave or store a firearm in a location where the person knew or should have known that an unsupervised minor could gain access to the firearm. And then if the unsupervised minor does gain access to the firearm, a person, the penalty structure is different than last year. So a person who violates this section is guilty of a misdemeanor conviction, subject to imprisonment not exceeding 90 days or a fine of $1,000 or both. Now, a person who violates subsection C2, this is new law, would be guilty of a misdemeanor and on conviction was subject to imprisonment not exceeding 2 years and a fine of $2,500. And then there's another penalty that's new as well. The person who violates the section is guilty of a misdemeanor and conviction subject to imprisonment not exceeding 3 years and a fine exceeding $5,000 or both. So that's the sum and substance of the bill. I would like to turn it over to the panelists because they will be able to speak more intelligibly and personally about how our current structure has left them exposed in some of their personal experiences. So with that, committee, I will turn it over to our primary witness, which is Ms. Herron. So Karen, you are up. I'm looking around here we go. There you are. You're up.
Okay, thank
Good
you.
to see you.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. I am Karen Herron, Legislative Director for Marylanders to Prevent Gun Violence. MPGV is an independent statewide grassroots organization dedicated to reducing gun deaths and injuries throughout the state of Maryland. Our work ranges from addressing data-driven legislative change, leading a violence intervention and prevention coalition, and running programs for at-risk children. Our mission is to work toward ending the cycles of violence that plague our state. I'm here to urge a favorable report on Jalen's Law, SB 479. MPGV has been advocating for this legislation for a number of years now because as a data-informed organization, we know that strong child access prevention laws actually work. In light of events of the last year, and particularly in light of the alarming spike in gun sales, the urgency to pass this legislation is stronger than ever. Recent reports indicate that Maryland ranks 6th highest in the nation in gun sales for 2020, and 2021 is looking just as high, if not higher. According to the Washington Post, January 2021, gun sales in Maryland were 80% higher than the same time 1 year ago. It would also appear that these high percentages, many of these are first-time gun owners. We know that it is not a difficult ask for gun owners to store their weapons in a manner that would prevent a young person from gaining access. We also know that Maryland's current law does not provide enough guidance or incentives for gun owners to consistently act in the safest way possible for their situation. This legislation provides both a structure and a flexibility for gun owners to take their own personal circumstances into account as to the specifics of storage methods, provided that the gun provided that the firearm is rendered inoperable to anyone other than the adult and is unloaded. Furthermore, this legislation does so in a way as to not infringe on anyone's Second Amendment rights. Current Maryland law requires gun owners to store firearms away from where a child under the age of 16 could gain access. There's no requirement to lock firearms or to keep them stored or unloaded. The American Academy of Pediatrics recommends that gun owners store all household firearms locked and unloaded. Maryland's current law is not in line with this recommendation and does not apply if the child is 16 or 17 years old. Nationally, more than 1.7 million youth live in households with firearms stored in a manner inconsistent with these safety guidelines. This legislation is needed to provide clearer gun storage guidelines for Marylanders to follow and to reduce these completely preventable tragedies. I would also like to note that given the limitations on oral testimony before this body this session, we are joined in our position on this legislation by various national gun violence prevention organizations, including March for Our Lives, Giffords, and Brady. We urge a favorable report. Thank you.
Excellent. Thank you very much. And next, we'll move on to, is Melissa here?
Yes, I'm here.
Oh, hey, there you are.
Yeah,
You're up
I'm
next.
just trying to get into a spot where the light is decent in here. I have a bunch of kids here home from school, so I'm struggling for a spot here.
We all know the feeling.
All right, I found one at the bottom of the stairs. Okay. So yes, we're all here for this bill. I just would like to say thank you for having me again this year, letting me testify. I have something I would like to read to you all. My name is Melissa Willie, and my daughter was Jalen, a 10th grader at Great Mills High School in St. Mary's County, located in rural Southern Maryland. We are a quaint community lined by Chesapeake Bay and tobacco barns, never the place you would expect to be gunned down. I'm here to tell you that it is essential that we pass Jalen's law to prevent my personal tragedy from happening again and to protect your children in our communities. Let me tell you about my beautiful daughter. Jalen was a good student, a member of the honor roll. She swam for both high school swim team and Great Mills Aquatic Club. Jalen had set the record for the 100 fly in February. She was a talented swimmer and earned her lifeguard license in 2017. Jalen had always had an affinity for the water and enjoyed vacationing with us, her family, at Connecticut beaches. She liked taking walks and was a delicious baker, especially her chocolate chip cookies. Jalen loved her siblings above all. On March 20th, Jalen walked out of my front door and into the halls of Great Mills High School. At the time of her murder, all she wanted to do was see her 13-month-old brother walk. She was excited to attend prom with a friend from swim team. She had gone dress shopping the weekend before. She didn't get to see either of those milestones and now has a little sister she will never cuddle, chase, or enjoy. Jalen was a vibrant, beautiful, sweet young lady. Her shoulders shook when she laughed. All at the hands of the gunman. All of that had been taken away at the hands of a gunman. The shooter was 17 years old, and he was granted access to a gun. We are here today to prevent another child from having access to a firearm, to help prevent another family from going through the horrific tragedy we wake up to each morning. I'm asking you to pass this bill in memory of Jalen Rose Willie, who died March 22nd, 2018, at the hands of a 17-year-old shooter while walking to class in her high school. That should never happen to Jalen, our family, our community, or anyone else. Thank you for your time.
Thank you, Ms. Wiley. I know you're juggling a lot, and so your continued advocacy and your presence here today, it means a lot. So thank you very much.
Thank you.
Next, we'll go to Ms. Landau. There you are.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and distinguished members of the Judicial Proceedings Committee. My name is Mindy Landau, and I'm a member of the Maryland State Executive Committee of Brady United Against Gun Violence and a co-founder of its Montgomery County chapter. Before retiring recently, I was a federal employee for 40 years. Thank you for welcoming me to discuss Brady's support for SB 479. This bill will encourage responsible gun storage and save lives by expanding Maryland's existing child access prevention law to ensure that fewer minors can access firearms. Many of you are parents or grandparents of young children. We want them to be safe. We know that 70 to 90% of firearms used in unintentional shootings, school shootings, and suicides by children under 18 come from their home or from the homes of friends or relatives. Studies show that children's lives are saved in states with strong gun laws. That is exactly what this bill will do. Strengthen a law that protects our children. The evidence shows how effective a bill like this can be. This proposed bill would prevent all minors under the age of 18 from accessing firearms because firearms are used in 44% of suicide deaths by 16 and 17-year-olds. Studies show that minors are not using other methods to attempt suicide when guns are not accessible. This means children may have a second chance at life if they can't find a gun. Incredible. Put simply, this bill can save lives. An expanded child access prevention bill will protect children from unintentional shootings, including suicide, and prevent them from being another statistic in a school shooting. Thank you for your time and attention.
Thank you very much. And next we'll go to Ms. Willis. Dr. Willis, you're up.
Hi, good afternoon. Dear Chairman Smith, Vice Chair Waldstreicher, and members of the committee. Marylanders to Prevent Gun Violence aims to reduce gun violence in Maryland through evidence-based solutions. The Kevin L. Cooper Foundation aims to mobilize Baltimore City residents to make an impact in the reduction of inner city youth death due to violence. I currently serve as the Director of Community Engagement for MPGV, and I am the founder of the Kevin L. Cooper Foundation, named in the honor of my son, Kevin, who was shot and killed at the age of 14. MPGV, the Kevin L. Cooper Foundation, and I support SB 479, which aims to reduce child access to guns to prevent the death and injuries of children. Each week in my role as the Director of the Community Engagement for MPGV, I work with young children at Liberty Elementary School. These children are in grief support programs that I run because they have been identified by their educators as being at risk because they have experienced a loss, be it in the form of death by gun violence, abandonment, or caregivers' incarceration. While the needs of these children differ from one another, one issue remains the same. Access to deadly weapons is a threat to all children, regardless of their race, socioeconomic status, or family composition. Maryland leaders have understood the importance of preventing access to young people in the past when they passed the existing laws, but we must recognize and correct the inherent weakness within our current access prevention laws. SB 479 addresses this weakness by increasing the age of a minor, clarifying storage requirements, and creating a meaningful penalty to enhance compliance. Currently, if a youth gains access to a firearm, regardless of death or injury, there's only a fine. Allowing a child to get access to a gun is a serious negligence offense, and the penalty should reflect that. Passing this law will help prevent young people while still allowing the legal and responsible ownership of guns. I urge you all to take a position and vote favorably for this bill. Thank you for your time.
Excellent. Thank you very much. And Mr. Bishop, you are up.
Thank you, Senators. I'm going to forego most of my written written testimony because the Senator had already addressed a lot of the issues in the bill and covered a lot of the questions or concerns. Today I'm testifying on behalf of myself as a firearms owner, a hunter, Marine Corps veteran, and most importantly as a father. As a strong Second Amendment supporter, I can confidently stand behind the concept of this bill I believe many of our Maryland firearms laws are burdensome and an infringement to purchasing and owning a firearm, while registrations can go against our Fourth Amendment rights. However, I also believe gun owners are responsible for maintaining reasonable control of their weapons at all times, just as any military member is expected to do. This includes keeping them out of the hands of unsupervised children or even violent offenders, which would be addressed elsewhere. Generally, there doesn't seem to be any intent to infringe on the right to keep arms in this bill, with, I think, a minor exception. And the only problem I really have is actually part of the old bill, and that's paragraph C1 that basically implies the little change is that a minor could gain access to the firearm. I believe there's situations that this kind of leads a very broad interpretation. I think the punishment, when the possibility exists that a minor could gain access, creating a punishment for that may be interpreted to be some level of overreach. But I like all the additions that are put into this bill. Obviously, everything in bold from paragraphs 2, 3, and down, including the punishments for those, also makes perfect sense, and I encourage that. I think there could be some tweaks to paragraph C1, and that might gain a lot more favorability from all sides of this issue. But I definitely sympathize with everyone here who has had issues. As I said, as a father, I personally take the extra steps to make sure there is no access for my children to my firearms. And I'd encourage a favorable reading of this bill with just some minor tweaks. Thank you.
Thank you, Mr. Bishop, and thank you for your service. And with that, we will move. That concludes the testimony for the proponents, and we will now switch over to the opposition panel. And we will start off with Mr. Pennick. I think I saw you here earlier. There you are. Mr. Pennick, you're up.
Thank you, Mr. Chairman. It's a pleasure to be here today. There are so many things wrong with this bill in terms of the legalities of it that it's hard to know where to stop. You have 9 pages of single-space testimony from you. That's a legal analysis. But it is, in short, impossible to comply with this bill because it imposes the impossible standard that you know or should have known whether a child under the age of 18 could gain access. If you look at the dictionary definitions for could, it is defined in terms of possibility. Now, I am a proponent of keeping guns away from minors as well, but it is impossible for me to know what is possible for a 17-year-old to do, because a 17-year-old can do pretty much everything an 18-year-old can do. And I have safes, including a 2-ton safe in which my firearms are stored. And it is possible for a person under the age of 18 to break into that safe. And let me turn to B5. The firearm is left or stored unloaded and has been rendered inoperable to anyone other than an adult. I'm 17 years old. I've been around firearms all my life. And I don't know of a way to render a firearm inoperable to anyone other than an adult. It's simply impossible for me to conceive of a situation. You say it has to be locked, but that bill doesn't say that. It says rendered inoperable, and that's not defined. Access is not defined. The whole structure of this bill is designed to be so incredibly broad and so incredibly vague, there is no way anyone will know a charted path to a safe harbor. And I asked the committee to compare this, you'll see citations to this in my written testimony, to other states' safe storage laws, which never define bar access by reference to what is possible, never define in such ways to leave a person who stores a firearm who with a hunter safety certificate could not have access to ammunition. The prima facie evidence of a violation of this bill is if you have a hunter with a firearm safety certificate with ammunition in his possession, because he has not stored that in a way that he could not access it. There's a circular problem here of internal inconsistency. How can you allow a person under the age of under 18, a 17-year-old with a hunter safety certificate, to go out and hunt on his parents' farm and have access to ammunition and then bar access to ammunition? It doesn't make a lick of sense. So I don't know how to comply with this bill. And I would, if you're going to have this bill, you need to define the terms. Otherwise, you're going to run straight into hell.
All right, thank you, Mr. Pennick. And we'll next move on to Mr. Spiker.
Good afternoon, Mr. Chairman, Vice Chairman Wallstreicher, members of the committee. My name is DJ Spiker. We haven't had the chance to meet before, but I am the new state director for the National Rifle Association. And look forward to working with y'all in your committee. I do represent Maryland, Virginia, North Carolina, and South Carolina. I've been with the NRA for just over a year now, and I appreciate you taking the time to hear from us today. As Mr. Pennick just touched on, we do have a number of concerns about the bill. We certainly do support the goal of this, and obviously the situation behind this is a tragedy that we do not want to see repeated. That said, we do have some direct concerns, certainly changing the age from 16 to 18. We have seen in other states that concerns about the trespassing into the hunting territory has certainly been an area that has been expressed as well. Last year in last year in Virginia specifically, similar legislation to this was amended to prevent it from going to 18 and leaving the age range in the original place. It's also important to note that current Maryland Code on criminal law, section 3-204, provides that a person may not recklessly engage in conduct that creates a substantial risk of death or serious physical injury to another. And that is being utilized in recent case law in prosecuting individuals who are leaving children with access to firearms. That penalty is 5 years imprisonment and a fine of $5,000 or both. So we do think there is opportunity in existing code without necessarily having to create a burden on law-abiding gun owners and increasing the penalties for safe storage in that area. As Mr. Pennick also touched upon, we do have some concerns about the contradiction. While we appreciate the exception for the hunter license in the section 4, number 1, by preventing ammunition, that certainly seems to contradict the exception for those individuals who may have a hunter license or a minor who may have a hunter license. So we do have some concerns about that direct contradiction. Again, we appreciate the goal of this legislation, but we do have some concerns. Lastly, I would just note that nationwide, we have seen a dramatic and drastic reduction in firearms accidents as it relates to minors, falling 91% from 1975 to 2019. The number of accidents decreasing from 495 to 51, and that is a rate reduction decreasing from 0.91 per 100,000 in 75 to 0.08 in 2019. We believe with incidents falling, subsequent, unfortunate tragedy, what we're dealing with this legislation, but in an existing code, we believe that there are other ways to accomplish the goal of what we're trying to seek here. Thank you so much, and thank you for the chair's time.
Excellent, thank you very much, and great to finally meet you. There you go. So next we have Mr. Benkert.
I don't.
Okay.
I'm in the room, but Mike Doherty is next.
Mr. Doherty, you're next. So there you go. Oh, one more time here. Click to ask to unmute you. There you go. There you go. We got it.
Gotta love Zoom. I have to deal with these types of tech issues in my day job. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. Mike Doherty, Maryland State Rifle and Pistol Association, in opposition to Senate Bill 479. My colleagues have made a lot of the same arguments that our organization would make. The biggest concern that I have from an organizational perspective is the use of the word could. There is no safe manufacturer on this planet that will make the guarantee that their safe is impenetrable. These safes are given common access to common tools available in the house. My safe here in my office is readily accessible with the angle grinder that's out in my shed, given enough time. So the use of the word could kind of places us in a black hole. From a private citizen perspective as well as an organizational perspective, my organization represents both private members and shooting clubs specifically that have firearms that they store in safes at various locations. This would put a massive hamper on things, because if the person on my club that is the one that is responsible for maintaining the firearms is storing them in a safe at his home, has a teenage kid, and needs to leave for a medical emergency, that magic word "could" now places him in jeopardy. So for that primary reason, we're opposed to the bill.
Thank you very much. And with that, unless Mr. Benkert has entered the room since, I think that'll conclude the testimony for Senate Bill 479. Thank you all. We'll now switch over to the committee for questions. Senator Huff is up first, and then followed by Senator West. So Senator Huff, there you are. You're up.
Yeah, that's just a question for the chair. I'm looking at the language. So it seems to me the last testimony was just about if you had it sealed in or you had to put in a case. For example, they have gun storage cases where they take a thumbprint to open them. So you could put it in there, a combination, whatever. It's often for handguns, you could do it. Well, this talks about a rifle or shotgun. So explain to me, if you have a handgun and you have it loaded and you put it in a case in Maryland, is that legal?
You have a handgun, it's loaded, and it's stored away?
Yes.
Stored away? And it's not accessible?
Well, it's stored away. So
that's legal.
Okay. So this is only dealing with rifles or shotguns. So this is only long guns that we're talking about here on your
This only applies to long guns.
So this is on long guns. All right. And so you could, in theory, leave it, but how do you leave because it says it has to be unloaded and then there's an end. So if you lock a long gun up and then you lock it into a cabinet, but it's locked up loaded, it seems to read as if the firearm is unloaded and not an or. So if you locked it up and it's loaded, how is that not violated?
So for handguns, first of all, let me backtrack. For the handguns, I'll get clarity on this, but so if it's stowed away, it still has to be unloaded, stowed away. This one, long guns, stowed away, it's requiring it both. Yes, ammunition separate and locked away.
So even if you have a gun that is locked in a case, you have a big storage cabinet. If that gun is loaded in the storage cabinet, it could be an armored one that you can't get in, but it has to be unloaded in that storage case, correct?
Can you repeat that? I'm sorry, I have 3 people in the room walking back asking for something. Can you just repeat that?
Yeah, so if you look at the bill, page 2, it says the firearm is unloaded and the ammunition the person owns has to be, goes into that language. The ammunition the person owns or controls is suitable for use of firearms in a secure location. It seems to read to me that if you had a secure storage cabinet, if you had a long gun in there that was loaded, that would be violating the law.
So that the way I'm reading it, that would be correct. If it's loaded, secured in there, under this language, yes.
Where is that provision for handguns?
I don't know that. I don't know the answer to that.
Okay, because here's what I get to. I mean, for self-defense, it's certainly, if you have you're basically talking about the difference between having a magazine and the gun, and just, if you have them stored together in a locked case, you're talking about the difference of, 2 seconds of putting it in, but most common sense people that are trying to follow the law would either for a handgun or a long gun for self-defense reasons in their home, if they have it locked either in a fingerprint or a storage case, they would leave it loaded.
So sorry, look, I think my apologies for your first line of questioning. So now I'm reading it. You got a couple things going on here, but sorry for that. So I think what you were reading was, you were reading under the exemption section on page 2. Were you reading these are
the person who stores or leaves the firearm stores the firearm loaded in any ammunition that controls suitable for use in firearm in a secure location where a minor could reasonably gain access, or the firearm is left. Page 2, starting at line 22.
So all of that is control. So it's, if you page 2, line 8, it's like, so this section does not apply if, and then goes into laying out the exception. So, stores that leaves a firearm or the firearm is unloaded and the ammunition and the person who owns the controls the suitable use in the firearm is secure location when a minor could. These are all exceptions. So I'm not.
So can you leave a loaded firearm in a stored locker?
So no.
Well, that was my questioning. That's what I was getting at. And what I'd like to figure out is I actually was trying to figure that out for handguns. I actually was unaware that in this state you could not leave a loaded handgun in a locked case in Maryland. So if we could figure out where that is, I'd actually like to see that. I know on transportation, when you transport, you have to have them in separate section of a vehicle, but I was unaware about a loaded if you have it locked away. So, I mean, that's news to me. I guess the second question is the language on reasonable strikes me as very vague, especially when you're talking about a constitutional right. I mean, what does that mean, reasonable? If I live in a household where I don't have children, or, I mean, I guess in theory, any child can go into somebody's home, but what does that mean? Does that mean they have it up high on a shelf? They got it in a hidden compartment in furniture? They've got it locked up? What does reasonable mean? There's no definition.
So the trier, I mean, this is something we actually commonly use, and the trier effect, I think, the reasonable person standard. So, I mean, it would be a fact-specific analysis. So it would have to deal with whatever hypothetical you put forward, whatever scenario was before the trier of facts. That's what they would use to sift through that. But I think it's pretty common, reasonable person standard.
So as the legislative intent is what, though? I mean, what are we advising Marylanders that this passes? What are they supposed to do? How are they securing their firearms?
You take reasonable measures and standards to make sure that, someone that's 18 or younger than 18 could not access your firearms, but for the exceptions laid out in the bill. So the policy reason behind this is ensure that folks are securing their firearms when they're unattended and they could be accessed by someone underage.
But I mean, that's reasonable. Somebody could say, look, I've got my hunting firearms up over top of the mantle. They've always been there. And I've got my shells for it. They're in my sock drawer locked away in the back, or they're the sock drawer in the back of it. Nobody should be rooting around in my drawer upstairs. So they'd be like, I think that's reasonable. What's reasonable to one person is not reasonable to another. So shouldn't we define exactly what we're instructing people to do?
I don't see how you could define that apart from just a case specific analysis.
What does it mean? What does it mean? Like I said, to me, that's reasonable. To me, that's a reasonable standard. I've got a shotgun over the mantle and the ammunition's up in my closet, it's up 7 feet high, tucked in the back. To me, that's reasonable. That's a reasonable standard to me, but I don't know if a court of law would agree. I mean, how do you know?
I mean, that's a case specific analysis, and you have to prevail upon the trier fact to get that.
If we're gonna make a new crime, though, we should actually explain to people how they should actually do this. If the idea is to actually prevent people from, if the idea is to have people do safe storage, shouldn't we instruct them what that means? And right now, it doesn't instruct them.
Oh, I mean, the bill, I mean, pretty prescriptive in that sense. It's got to be, rendered inoperable and inaccessible. So, I mean, I'm not really, the guidance is pretty clear to me. But.
All right, so I've got the gun unloaded. I got a trigger lock on it, and I got the ammunition up in my bedroom in a separate, up in my closet in the back of the closet. Is that reasonable?
Well, I think that if it's easily accessible, then probably not.
So then that's not reasonable.
Look, I'm not the trier of fact in that situation, but if it's easily accessible, then I think you've kind of proven that it's not.
I mean,
that's not reasonable.
I put it in a drawer. You got to open the drawer and it's in the back. I mean, I just think we should have in there plain language so people understand. I guess the last thing I'll leave on this is people are testifying about preventative. Well, in fact, I mean, we're sitting here trying to figure out what the current standard is on handguns. And we're the people that write these laws. And so the idea that everyone's going to know when we pass this, they're not going to know all this stuff. So the question is, this is not actually a preventative bill. This bill is only enforceable after the fact. Isn't that the case?
One more time. Can you do it one more time? We get a lot of people coming in. One more time, please.
Well, I mean, the bill, people are testifying as if this is a preventative bill, when in fact, this bill is really only going to be enforced after the fact. Because unless we're going to have people start police going through people's houses and inspecting and looking at their guns and getting warrants and all that, this is only going to be enforceable after the fact.
I mean, I suppose you could say that with almost every element of criminal law. I mean, you have consequences for actions, and if you have the consequences are a deterrent for that behavior. So I probably disagree with you on that one.
Well, okay, so I guess I'll just leave it at this, that I think we pass a lot of laws down here. I don't know that they're clear to people, and this one is unclear to me exactly what it means. I own a fair number of firearms, ammunition, but my children are trained. That's what people should do, is train people on firearms, to how to handle them safely, which we're not doing or addressing with this legislation at all. And I worry that if we put out something that is so broad, people are not going to understand this. They're not going to understand what it means. And we need to be more specific about people. If we're going to make it a crime and punish and incarcerate somebody, unless we're going to have the state police start raiding through people's houses and checking on how they have their guns secured. I guess they could, if they come into your house, they come to your house or something, they can see a gun on the mantle and say, show me where your ammunition is on that. I guess they can start enforcing it that way, but that's going to be, I wouldn't want to see that, but okay, thanks.
Excellent. All right, Senator West and then Senator Bailey, you're next. Sorry, you guys keep close the door.
I keep unmuting myself and getting remuted. So thank you, Mr. Chairman. I do have a number of questions here. So I think in response to one of Senator Huff's questions, you said this bill only applies to rifles, but I'm looking at the definition of firearm at the top of page 2, and the bill uses firearm over and over all through the bill.
That's right.
It says firearm means a handgun, comma, rifle, comma, shotgun, etc. So clearly, it appears to me as if when the word handgun is, excuse me, when the word firearm is used, the bill refers to handguns as well as rifles.
That's absolutely correct. And so I was, again, sorry, distracted. I was talking about the exceptions, and the exceptions deal with the long gun. So that was on page 2, and so page 2, line 15, that's what I was talking about. So my apologies on that. Yes. So to be clear, it's all firearms, but the exceptions were with a long gun, the rifle or a shotgun.
Next question. Further down on page 2, we have certain privileges accorded to minors, who I guess are 17-year-olds and younger, who has a certificate of firearm and hunter safety issued under the Natural Resources article. Are those things hard to get? Do they require an awful lot of training, time, or is it fairly simple for a minor to get one of these certificates?
I wouldn't say simple, but it's and I think either Mr. Panic or actually Mr. Doherty may be better, because they may have actually participated in instructing these courses. But it's not simple, but it's you could probably do it within a day.
Okay, so you go off for a Saturday and you're awarded the certificate by the end of the day.
You get some basic competency, and it's here we go. It's 16 hours of training for hunting, and you got like a test, but so you could get away with it in a weekend, I should say.
Okay. Next question. At the bottom of page 2 says.
Hold on, Mr. Doherty can give you some more context on that. Let's ask.
Okay. Bottom of page 2, subsection 5.
Senator West, just real quick. Senator Doherty's going to give you right now some more context.
Oh, I'm sorry. Okay. Yeah, sure.
So just in answer to some of the questions, there is a live fire requirement component to the hunter safety courses. You have to attend a field day event, and the field day events are not commonly scheduled. There are a handful of them done every year throughout the state, but it's not something where I could say, I want to go tomorrow to do a field day event. It has to be coordinated and look at the DNR sponsored field day events, but to complete that portion of the training requirement.
Okay, how many hours of training are required in order to get one of these certificates?
That one I don't know specifically in Maryland. I got my hunter safety course when I was 15 years old in the state of Virginia. So I haven't actually been through Maryland's program.
I pulled this before last time. I think 16 hours, but I can give it to you.
Mr. Pennick had his hand up. Is it 16 hours? You can nod your head yes.
No, it can be done in a very long day. It's averages between 12 and 14 hours, depending on how many people in the class. There's no time limit on it, so much as you have to do X. It's up to the instructor and the number of people in the class. There's a live fire requirement, but it's live fire of a long gun. I've never seen a hunter safety class taken for a live fire of a handgun.
Okay.
So
that's helpful. Thank you. Let me go down to the bottom of page 2. Section 5. This is under this section does not apply if 1, 2, 3, 4, 5. So we're in the 5th section there. It says the firearm is left or stored unloaded and has been rendered inoperable. I don't own guns, so I'm not familiar with all the intricacies of guns. If you're storing a handgun unloaded, what more would you have to do in order to render it inoperable than take the ammunition away from it?
A safety locking device.
So what would that add? If there's no ammunition in the gun, why would you need a safety locking device?
So if it's inoperable, I mean, you couldn't pull the trigger, you couldn't.
Yeah, but if there's no ammunition, there's no ammunition. You know, people on stage pull triggers all the time, but they're not loaded with real ammunition.
You asked about inoperability. You can't operate it if you have a trigger lock. I mean,
I don't understand what that adds to the. Once you take the ammunition out, I mean, again, on stage, people fire guns directly to each other, and they go off, and nobody gets killed because there's no ammunition. So nobody in the audience feels scared that an actor is going to get murdered on the stage. So in someone's house, if there's no ammunition, why would you need to do anything else to a gun to quote render it inoperable?
I mean, I think first of all, I mean, you always treat every firearm as if it's loaded, but I think it's a good policy call to make sure that it's inoperable so that you can't use that firearm if it's unattended. If you have the ammunition, even if it's separate, it's a policy call, right? So I think it's exactly what you want to ensure that the firearm that's before you is safe. And so you or no one else would know whether that weapon was loaded if you came upon it fresh. And so inoperability, I think, is a core component of this.
Okay. I guess, Mr. Pennick, are all firearms capable of being rendered inoperable?
Well, sure, you can take
Yes.
a blowtorch to them and destroy them.
No.
But I don't know of any way
inoperable, but in a way that you could once again make them operable with relative ease.
This is not a defined term, Senator. We don't know what that means. Now, Senator Smith says a lock would do it. Well, that's not inoperable to a person under the age of 17, but operable to a person of over 18, because it may be locked, and that may prevent the access to it. If you change inoperable to mean locked, that at least would make sense. But I don't know what that means, because if you render something physically inoperable, which is what the sense of that word is, then it's inoperable to an adult as well, like you would with a blowtorch. So maybe you could change the language to, so, I mean, you did this in SB 441 2 years ago, and you had a safe harbor provision, Senator, with respect to if the gun was locked. But that language has been abandoned, and I don't understand why. Because if the object of this language is to render it has to be locked, you should say so. Rather than
Mr. Penning, let me ask you the same question. If we change the language from inoperable to locked, are there ways of locking up every single gun, or are there some guns that are unlockable?
Well, every single gun can have a trigger lock on it. And if the trigger lock is sufficient, that would be great. But this is in conflict with basically C1, which says an unsupervised child could gain access.
I'm gonna get to that. Let's not get ahead of ourselves.
Okay.
I'm getting there. So my next question on page, is it 3? I've written over it. Yeah, page 3. For the sponsor of the bill, do sections C1, 2, and 3 all only apply to loaded firearms? So an unloaded firearm would not be subject to sections C1, 2, and 3.
So C1, 2, and 3 on page 3. So rephrase your question, say it one more time. Would it only apply to a loaded or unloaded?
On page 3 of the bill,
Yes.
subsection C1, 2, and 3, which are the ones that are then criminalized down below,
Yeah.
do those sections only apply to loaded firearms, or do they apply to unloaded firearms as well?
Both.
Both. And unloaded. Okay, I couldn't tell that.
You're going to have to, I mean, yeah, to get the penalty, I mean, obviously you can see what, you just got to do some work with marrying it up from 1, 2, and 3 to 1, 2, and 3 above, but.
Okay, now let's come down to this word could. And I've quickly paged through the opposition testimony, of which there's a great deal. And almost everybody seems to refer to could. I was trying to think of my house, Mr. Sponsor. I can't think of any place in my house that I could put something that a determined 17-year-old could not get at it. I wonder, in your house, is there any place in your house where you could put a firearm where a 17-year-old with time and determination could not possibly get at it?
So I think look, we've had this discussion actually even earlier today. I mean, in the I think proposed, which I'm not sure I accept here, but the proposed suggestion would be to just simply add reasonably could, which I think you've even heard in testimony. I would be at first blush opposed to that. And I think if you've taken the measures to lock, I mean, because could deals with like a logical possibility with all resource and all time. And, so it's an academic question. I'm not quite sure the answer. And I'm not sure I'm ready to accept the reasonably could language fixed to it, but it is an academic question.
We're all state senators, and unfortunately, our home addresses are easily available to people. If I start to get I don't have a gun right now in the house, but if I started to get threats from people, and I know I'm down at Annapolis a couple days a week and my wife's at home alone, I would consider buying a gun. Fortunately, I don't have a child on premises these days, but assuming I did, and I wanted to get a gun, I can't think of any place in my house where I could put that gun but where a 17-year-old would not be able with some time and effort to get at it. So it sounds like this. Is there any house that you're aware of where you could put a firearm where a 17-year-old could not get at it?
Again, that's what I'm saying. Like, I understand the reasonably could qualifier. I'm not, quite ready to accept that. And I suspect that, I guess, given ultimate time and infinite resource, you could do anything. So I understand where you're coming from.
Okay, let me go on then to further down the page and subsection D. I'm going to propose the same hypothetical, Mr. Chairman, that I posed last year when this bill came up. So you have a single mom, and she has a handgun for protection in case someone tries to invade her house. She also has small children. So we don't all keep tidy houses. I try to, but I will admit that even my house, it sometimes looks like the wreck of the Hespers. So let's assume the single mom goes to bed and for whatever reason has left the gun on the kitchen counter, and she and the kids are upstairs and she hears something downstairs. It sounds like someone's trying to break in the house. She calls 911 and the police arrive and the invader has fled, but the police, while they're there, see the gun on her on the kitchen counter. Under subsection D1, it looks to me as if she could be imprisoned for 90 days. And I'm wondering what happens to her kids while she's in jail. I would guess they'd be put in foster care. Is that what this bill is? Are you comfortable with the collateral consequences of this bill? That in that scenario, the children of a single mother would go into foster care for 90 days?
Again, I mean, I think you answered this question before. I mean, look, that's not in the exception list. So, I mean, I suspect that's within the realm of possibility, but not probability. If a trier of fact got those sets of facts there, but if she, yeah, I mean, it's not within the exception, as you have ably pointed out.
Okay. And then finally, I just want to note, I think it was maybe Senator Huff that raised this point, and I share it. Most people don't know all the intricacies of legislation that we passed. And this particular bill is full of intricacies with exceptions and exclusions from the exceptions. And it's very complicated. I guess I'm concerned that it's so complicated that a normal family who hasn't been informed about all the ins and outs of this bill and are not trained lawyers aren't going to know what they're supposed to do. But I guess that's just an observation. It's not so much a question. So with that, I'll conclude.
I get it. I mean, that's probably the same could be said for any intricate piece of legislation we pass every day here. But
yeah, but at this, I think we have to be really careful about passing legislation that criminalizes conduct in someone's private home. Lots of other pieces of legislation criminalize conduct that occurs out in public. But in terms of criminalizing stuff that happens inside a private home, to pass a piece of legislation where the people who live in the home don't understand what they have to do and face going to jail if they don't do it, I think we need to think twice about that.
We passed legislation that deals with sexual assault, rape, murder, all of which occurs within the home. It's criminalized. So again, I just say we do that every day here in JPR. Okay. With that, I will, looking around the Zoom room for additional questions. Senator Bailey. You unmuted and muted, so here we go. There you go.
Okay, are we good? Thank
you. Good.
Very, very much. I don't know if on your side of the building you're having the heat wave that we are over here, but it's
cold over here.
Well, let me tell you, it's about 90 over here. So if we're sweating, right, it's on purpose. So quick question, and Mr. Chairman, this would be for you. And I just wanted to, I'll give you a perfect example. You and I are sitting here side by side in Annapolis. My wife is working today. My two children are at school, and in another hour, they'll be done. If they wanted to go out and legally hunt on our farm this afternoon with their mom being gone and me being here in Annapolis with you, how under this bill can they do that legally?
Well, it's one of the exceptions. So in the minor, which we changed to 18, has a certificate of a firearm hunter safety issued under sections 10.301 of the Natural Resources Article.
Right.
And has been given the permission, which you obviously have given them.
Right. And how can they get to the ammunition?
If you've given them permission to access both, that applies to both the firearm and the ammunition.
Does it?
So that is not the way that I read that at all. That does not give them permission for the ammunition. So I'm just saying that that is something that clearly needs to be addressed. And the other fact of that is we can leave our children at home, and they definitely have their constitutional rights when they're left at home. And clearly one of those is in self-defense. And if I, as a parent, have instructed my children, and I'll have to say, I can answer in the committee all the questions about safe storage, I am a firearms instructor. So I have taught hunter safety for years. I have no problem doing that. Part of that program teaches in depth what we teach in Maryland with safe storage. People that have, I want to say that in the last 20 years, the records that we have kept on people that have gone through a hunter safety course, I'm not familiar with a single accident that has occurred with that as a result of a safe storage. The situation and the way to get to a potential problem and some of the tragedies that we've heard is through education. And I think that that is definitely a component that we should work towards. And I will be more than happy to explain to everyone about the education, how to do safe storage. We teach safe handling. That is a big part of it. And I think it's important for children to learn that. And I just think that when I grew up, we were able to get home, and if we wanted to go shooting or go hunting, we were able to do that. And I don't think, and if for some crazy reason, if something had happened, that somebody had tried to gain access into our house or harm us, we would have been able to protect ourselves. And I think that's something that parents that are cognizant gun owners and have taught their children that they want that same right for their children. And I think that's a right that's granted to them. And I think that we are potentially taking that away from them in this incident. But I'll be more than happy to work with you and talk to you about this. And I will actually, when I go home this weekend, I'll get some more books on hunter safety so that we can have them accessible so we can show the educational component. Thank you.
All right, thank you, Senator Bailey. I think we have one more question, Senator Huff. There you go.
Yeah. Just from listening to the back and forth, what is the mens rea standard on this?
The mens rea standard for, like, if you intentionally leave it open or like, is it or forgetfulness or like intentionality? I mean,
well, as the author of the bill, how would you, I think it's very important that we have mens rea standards and we have criminal intent in our laws so we don't have over criminalization. What is the mens rea standard for this?
It's just, I mean, you've got, the intent is, I mean, you have to store it, and if you don't, so there's an intentionality there. So, I mean, I'm not really quite.
Well, because you said the reasonable standard is up to the trier of fact, not to the
person standard. Yeah.
So the individual determines it's reasonable, and I believe I have reasonably complied with the law. But you said it's up to the trier of fact to determine reasonable. So in that case, how do you determine mens rea? Because the person believes they have acted reasonably and they have complied with the law. They did not go in with the criminal intent to break the law, or most likely they were unaware of the law. So how do you determine the crimes that you mentioned that happened in the home, sex assault, clearly, and any kind of physical assault, there is a mens rea intent. What is the mens rea intent for an individual who believes they acted reasonably and the trier of fact disagrees?
So here, it's stated 3 times, I guess, on page 3, which is, it's just knew or should have known. And that's the stated, mens rea there. I mean, mens rea for this bill, it's knew or should have known, stated 3 times on page 3. So that's, I guess that's the simplest answer for you is knew or should have known.
But again, they believe they stored it reasonably, and that was their reasonable belief. They can go into court and they can explain they put it in a reasonable location in their home. They truly believe they were in compliance. But with reasonable being so broad, how can you have a mens rea standard when it's up to the trier of fact to determine reasonable when it's not defined?
And it's a common, I mean, that's common within our, I mean, reasonable person standard is a common thing, but the mens rea question is either you knew it or you should have known that you took those actions to store your ammunition and your firearm.
In a quote reasonable manner.
That's the, pretty standard issue stuff.
So and you as a chair, and I really want to drill this down. What is if this passes, what is the instruction? Because the law is not clear. This is not clear to me when I read this. Reasonable doesn't 1,000 people can have 1,000 different interpretations of that. So the intent is you want it all locked up, the ammunition. Would anything other than that pass through your standard of what you want here?
The ammunition that is properly suited or usable for that particular firearm should be locked away under this bill. The firearm should be rendered inaccessible.
And you need to have a lock on
Should
it.
have,
Okay.
the mens rea is newer, should have known, and the umbrella is.
And you have obviously, and there's no exceptions. I mean, you brought up assaults in the homes and things like that. So if somebody there's no exceptions for police officers, for people who have protective orders, for any of those people. And, I'll just leave it on this. My last thing, I find ironic that we're supposed to put our trust completely in the police to protect us. And then later today, we're dealing with bills because we distrust the police. So now people have to be able to protect themselves if they have an abuser, they live in a bad crime-ridden neighborhood, and they're going to have to unlock the gun and run upstairs and unlock the ammunition while a domestic abuser is busting through the house. Is there any cutout for somebody who has a protective order who's under threat?
No, there isn't. And I mean, I just think that, there have been several circuit court decisions. The Ninth Circuit most recently has spoken to this, that if you have your gun, let's say in a biometric locking device, that's not unreasonable. It does not run afoul of Heller, and you can have that readily accessible for yourself.
But you can't have it locked in your biometric device.
If you have it on your person.
Or you can't have it loaded. You can't have it loaded on your biometric device.
Well, actually, it's more research while this is going on. So as long as it's inaccessible, it can be loaded. And Mr. Pennick, you can check me on that.
Yeah, I'd like Mr. Pennick to weigh in because it seems to me that you couldn't do that. But
So as this bill is written, no firearm whatsoever can ever be stored loaded, period, full stop. And it doesn't matter whether it's whatever the needs are. It bans by taking out the existing laws reference to loaded, it simply bans the storage of a bill that could be a firearm that could be accessed by a minor. And so the mens rea here is really known or should have known what is possible for a minor to do. So I've been that Department of Justice for 30 years. I never saw a mens rea like that. Excuse me, a mens rea like that. I mean, that's not a mens rea requirement because the mens rea is by reference to possibilities. Well, that's an impossible mens rea because no one can know what's possible.
Let me ask you this: reasonably could.
Well, that isn't what it says. Honestly,
I'm asking that question though. Reasonably could.
Reasonably could means what's reasonably possible, and that's almost a nonsense sentence because what is reasonably possible is apart from what's possible. I don't know how to answer that.
If it said reasonably could.
If it said reasonably is likely, like the California statute referenced in our written testimony, that would be something people could understand. And if you want to change that to likely, then that might be something that people could then understand in their particular circumstance and a trier fact, what would be likely in that. But right now, it doesn't even matter whether or not you have a child in your home because it's any child anywhere. It doesn't matter whether or not you have children or never have children in your house. So that's an impossible standard as to know what one child somewhere could do possibly. So you have to give us some standards to apply. Otherwise, the trier of fact is left without any kind of standard to apply. So I'm asking you, I don't want to suit it on this. I really don't.
No, I see the point of Senator West. I mean, I understand that. We had that discussion earlier about could, reasonably could, not the likely language, but I understand.
So you won't leave us any choice if this goes through as written.
But again, back to the circuit court decisions, and it obviously doesn't apply if it's on your person for self-defense, and if it's easily accessible, even if it's locked away, has been determined not to run afoul of Heller. So,
well, Heller does say that it has to be available for immediate self-defense. And the
Heller dealt with disassembled firearms.
Disassembled or locked with a trigger lock was a statute there in DC.
So you have this Ninth Circuit decision that comes back and says that
the most liberal circuit.
I mean, the Ninth Circuit, it's still a circuit court, man. It's still a circuit.
It is. It barely.
Senator, if I could just make a point about the Jackson case, that had an exception for locked firearms, and this statute as written, this bill does not. This says inoperable, whatever that means. So please define inoperable for us.
Then you have, again, I mean, I just think the trigger lock makes it inoperable, but yeah, I mean, I think you've got the New York decision, another circuit, different circuit, Second Circuit said that it was by locking the safety device, it does not run afoul of Heller again. So,
well, if you want to define inoperable that way, that will at least eliminate that kind of, at least give us a safe harbor. Because right now, every gun owner in the state is going to become a criminal when this becomes law. Because nobody knows what a child under the age of 18 could do, or what is rendered inoperable means. I don't know what that is. I've been practicing law for 45 years. I have no idea what that means.
Second Circuit and Ninth Circuit seem to have figured it out, but okay.
Define it as locked then. That will at least give us a standard to apply.
Now, you know, I respect you immeasurably on this stuff. So I'm, you know, happy to work with you on this, just to have a disagreement here, but definitely want to work with you. I found your,
happy to do so, Senator.
your expertise valuable to the committee in the past. Okay. Looking around the Zoom room, every Republican has had their piece except for Kathleen. So I'm getting out of here. So that ends the, there it is. All right, that ends the hearing. There, I got it. That ends the hearing for Senate Bill 479. And now we will move on to our last two bills of the day, Senate Bill 400 and Senate Bill 420. Senator Carter, Senate Bill 400, you're up.
Good afternoon, members of the Judicial Proceedings Committee, Chairman Smith, and everyone that's watching. I am very pleased to present this next bill. I want to acknowledge that it's not yet 3 o'clock. I will do my best to keep our momentum going because I know that we have a long day. So the bill that I'm presenting now is, I was asked to file, actually weirdly, by several different people in several different ways. I think largely due to the notoriety of publicly reported instances of racially targeted false reports made to law enforcement against Black Americans in numerous different jurisdictions in this country. And so this bill, Senate Bill 400, is designed to do two things. The purpose of it is to help prevent the targeting of marginalized people and to prevent the weaponization of law enforcement against Black people and other minorities. I'm very pleased that I'll let my panel speak shortly, but after I say a few other reasons why we need the bill, but I'm pleased that my lead proponent on this bill, maybe a first, maybe an only time, is none other than Scott Schellenberger. And I'm also will be joined by Willie Flowers, who is the president of the Howard County chapter of the NAACP, who has his own personal story and is actually one of the several people that contacted me in reference to sponsoring such a bill. And then also, I'm also pleased to have Zainab Chaudhry from who represents the Council on American Islamic Relations. Now, we talk a lot about, is this an issue in Maryland? I posit to you that it is. These kinds of racially charged calls are not new, but there is a growing trend across this country to begin to stop them and penalize them. I am an avid user of social media, and so I'm well aware of the trend in social media to refer to these kinds of calls as Karen calls. Karen is often used symbolically as the type of individual steeped in white privilege supremacy that would make false calls against people based on their race. But what Karen actually stands for is a caution against racially exploitive non-emergencies. Most notably, one of the most prominent examples of this type of situation occurred in New York City's Central Park, May 25th, 2020. On that day, Christian Cooper, a Black man, was bird watching in the park when Amy Cooper, a white woman, walked into his vicinity with her dog unleashed against park rules. Knowing the rule, Christian Cooper requested that Amy Cooper leash her dog. Amy reacted by approaching Christian, jutting her finger in his face and threatening to call 911 to tell them her quote, "An African-American man is threatening my life." Shortly thereafter, she made good on her threat, claiming to the 911 dispatcher that there is an African-American man in Central Park threatening myself and my dog. At the end of the call, she pleaded with dramatic flair, "I'm sorry, I can't hear you. I'm being threatened by a man in the park. Please send the cops immediately." Fortunately, Christian was recording the encounter on his cell phone, conclusively proving that she falsified the encounter and the 911 report. Her intent was clear, though, to punish and intimidate Christian Cooper for requesting that she leash her dog by intentionally deploying historical anti-Black stereotypes against him with what she thought would be a sympathetic ear, law enforcement. Thankfully, the situation did not escalate because Christian in this instance had not only a calm demeanor, but a cell phone where he could video record the entire incident. I want to say that these kinds of calls are not only deplorable and abhorrent and racist, but they're also a tremendous waste of resources when it comes to law enforcement, keeping them away from real crime and real pursuits for things that they should be pursuing. And so I'm happy for you to hear from my wonderful panel, and I'm happy to join with them to answer any questions. Thank you so much.
All right, thank you, Senator Carter. Your primary witness is Mr. Schellenberger.
Thank you so much, Mr. Chair, members of the committee. Chairman Smith, I'm sure those words you never thought you'd ever say out of your mouth with Senator Carter and I. And Senator Carter, thank you for putting this in. It's timely and well needed. And just so you know, last week I testified in favor of a bill from Delegate Moon. So there are many people looking at me wondering what has happened to me. But what has happened to me is this is the right thing to do. So you've told us about the incident in Central Park. Let's not forget what happened just after Christmas when a 14-year-old young Black man was accused of stealing an iPhone in a New York City hotel. And a very similar thing happened. It was readily apparent that the accusations occurred because of the race of the victims in those cases. And it's really a tragedy to have something like this. And what this bill does is Senate Bill 400, it would make it a hate crime to make a false statement to a police officer when the false statement is motivated as a result of the race, color, religious beliefs, sexual orientation, gender, disability, or national origin of another person. Why does this matter? Because simply making a false statement to a police officer carries a maximum penalty of 6 months in jail. So a false statement to a police officer, 6 months in jail, that's it. So what Senator Carter has done is to add that if it's motivated by one of these hate motives, if the motivation for the false statement is motivated because of race, and then the other categories I named, then that false statement gets elevated, and it gets elevated to typically a 3-year misdemeanor. Now, if you're committing other crimes when this occurs, then it could even go up to a felony. But I think more likely than not, the two cases that have been in the news, New York City and Central Park, would make it at least a 3-year felony. And so what we want to do is, if you just label somebody that they got convicted of a false statement, they can 3 or 5 years from now tell you anything. They can say, oh, I lied to a security guard when I was shoplifting. But when you call it what it is, and that is it was motivated by hate, then that person is labeled as a person who is motivated by hate. And shouldn't their record reflect that? Not only the penalty and the potential penalty should reflect that, but the fact that they are motivated in that way should be reflected. And obviously, I, as a prosecutor, I'm going to have to prove that that's my motivation. And you know, I was listening to the testimony the last time. Remember, I have to prove the motivation beyond a reasonable doubt. not just the statement's false, but that I have to prove beyond a reasonable doubt what the motivation is. And that is a pretty high standard. And that kind of goes in line with the conversation you were having during the last bill. I think this Senate Bill 400 is a very common sense way to move forward. And I think it's one that we should take now, particularly in light of the incidents we've seen over the last year. I would, however, remind everyone that in Maryland, because of our wiretap statute, when they pulled that phone out and recorded that conversation, that would be against the law in Maryland. I don't mean to pick back up on our prior conversation, but when you pull that phone out and record that false statement, that's a wiretap violation in the state of Maryland. So we'll talk about that another time. This is a very good bill, well drafted, well crafted. I highly support it.
All right, thank you very much. Next, we'll have Ms. Chaudhry.
Thank you again. Good afternoon, Chair Smith and members of the Senate Judicial Proceedings Committee. I'd like to thank Senator Carter for her leadership on this issue. This is obviously an issue that impacts a very large chunk of our constituency here in Maryland. On behalf of the Council on American Islamic Relations, we strongly support Senate Bill 400. In recent years, obviously, we've seen a significant uptick, as Senator Carter mentioned, in the number of reports of racially motivated 911 calls across the nation that have gained a lot of national headlines. My organization has also received concerns from community members here in Maryland who feel like their race or religion has been weaponized by individuals who harbor bias towards them. Some have changed their behavior or the way that they dress or appear in public. One family reported to CARE last year that they moved out of their predominantly Caucasian neighborhood for fear of being targeted in this way. Obviously, the function of law enforcement agencies is to protect and serve. Their designated purpose is to summon the police in case of an emergency. But unfortunately, too many people often feel entitled to exploit the system to make the police complicit in their racial bias. It's time for the Maryland General Assembly, we believe, to take action to prevent these dangerous calls. Needless 911 calls in non-emergency situations are a waste of resources, of tax dollars. They endanger the lives, especially of communities of color who are directly and disproportionately impacted by them. We support this bill because we believe that it sets the tone for accountability, and we believe that it will help discourage this kind of behavior in the future. We believe Maryland should join the likes of many other states across the country who are starting to legislate action to discourage these kind of calls, and we respectfully urge a favorable report. Thank you. I yield my time.
Thank you very much. And next we will have Mr. Flowers.
Good afternoon, Chairman Smith. I guess I'm back. This is, I guess, the second phase of a Karen call bill. I'm stepping in again from the NAACP Maryland State Conference, and we support the bill. We support the bill for everything outlined in the description, but as a, I don't want to go into the same speech I did last time. I'll just say that this bill tackles and makes it a hate crime, which is significant and important. And I think it helps to mitigate these calls. And I wanted to, while I did the presentation or testimony in the last hearing about the Karen call, after I did that, I remembered that on another occasion in the state of Maryland, because there was a concern about the state of Maryland not being the place where this stuff happens, I guess. But I lived in Baltimore City, and in 2004, while sitting on a park bench, I was basically arrested for sitting on that park bench and taken into central booking. While, as everyone here knows, that there was a history of these illegal arrests in Baltimore City, that was, I found out later, was a matter of a Karen call. And what it resulted in was two things. I moved away from the city of Baltimore, and I also sued the city of Baltimore and won. And the city of Baltimore had to pay me for that type of nonsense. And I expressed in the last testimony where this, so that's a, the city of Baltimore had to pay for something that could have been avoided. And in the last situation, I had to pay for an attorney to do that. So there was an inconvenience to me, friction caused between me and my community and me and and the police. And this type of trends follow it. So there's a conflict that's created with the police who are trying to do their job who would rather be doing their job and not answering calls that are unnecessary. I want to get into the more recent one that happened to me in Howard County, Maryland, where a young man called the police after a conversation I had about a political candidate of all things. But that resulted in me having a peace hearing that he didn't show up for. And then I had to get an attorney to prepare for a assault charge that was heaped against me that was dismissed. Now, all of that speaks to resources lost by everybody except the person who called. And so I think that this bill and any bill, I want to highlight that it wouldn't be important if there wouldn't be two bills if it were not important or if it was not an issue. And I'm bringing it where the rubber meets the road. So I certainly, the NAACP supports this bill, and I hope that the chairman and everybody on this committee can see the value of it and how it would eradicate this type of friction that's happening between the police and communities, and will restore some type of understanding of what these calls are. Because there should be education of the caller to the caller about what, when you should call the police, and that clearly isn't happening now. So I thank you, and I encourage approval of this bill. Thank you.
Excellent. Thank you very much. Next, we will go. So that concludes the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and that's Oppenheim. You're up.
Thank you. Good afternoon, everyone. My name is Todd Oppenheim. I'm an attorney of 17 years in the Maryland Office of the Public Defender. Before I begin, my office wants to commend Senator Carter for not only being an ally, but a true champion for indigent defendants and justice reform. Thank you, Senator. However, the OPD respectfully opposes Senate Bill 400. Despite its best intentions, Senate Bill 400 furthers policies of mass incarceration and perpetuates an unequal justice system that disproportionately criminalizes people of color. As they are, the laws of the state of Maryland provide plenty of prison time for judges to order upon conviction. Senate Bill 400 targets conduct for which there are already existing laws with sufficient punishments. The OPD understands that the rationale for Senate Bill 400 goes towards the protection of vulnerable populations, including Blacks and LGBTQ individuals, along with other marginalized minority communities. However, in our broken justice system, the very groups that the people that this bill aims to protect also inevitably become targets of its enforcement. These vulnerable populations comprise OPD's client base, so we carefully consider our position and recognize the unique circumstances of the good and the bad of Senate Bill 400. Ultimately, we oppose the bill because of the detrimental impacts it will have. The OPD recognizes ongoing instances of biased and prejudiced policing, prosecution, and sentencing all across the state that specifically affects our clients. The entire system is flawed from beginning to end. So any new criminal law, no matter its intent, when enacted in our justice system in its current state, can't be expected to have an equal application in the community. We recognize that Senate Bill 400 seeks to prevent undue targeting of individuals based on their race, gender, sexual and orientation, religion, disability, national origin, or whether a person is homeless, which is commendable. However, just as neither the death penalty nor mandatory sentencing deter the crimes for which they cover, the main results of legislation like Senate Bill 400 will simply be increased prison sentences. Meanwhile, hate will continue in society. The bill offers increased punishment for crimes already prohibited in laws like Maryland 5901, which already prohibits all false statements to police officers. Senate Bill 400 adds an extra measure for false police reports based on hate crime premises to Criminal Law 10304, and in doing so, increases the penalty sixfold. That seems excessive. Instead of an arbitrary increase in potential jail time for offenders, we should direct resources to root out the ideas and beliefs permeating society that cause hate crimes in the first place. Another important point is that the inherent difficulty imbued in hate crime legislation is improving the intent behind actions. Similar to theories of conspiracy and other inchoate offenses in criminal law, hate crime laws seek to get inside the minds of the accused as to their motives, even when those motives are often not clear. It seems draconian to not only create new offenses that focus on intent with these difficult issues of prejudice, but to also severely increase the penalties. The OPD certainly appreciates the goal of this legislation. However, with an unequal, unpredictable justice system, We cannot take the chance that these new laws won't be turned around and used against our own clients or applied in a disproportionate way. For these reasons, the Maryland Office of the Public Defender respectfully urges an unfavorable report on Senate Bill 400 from the committee. Thank you.
Heard, excellent. With that, that'll conclude the testimony for Senate Bill 400. We'll now switch over to the committee for questions. I saw Senator Hedelman first, and then I'll go over to Senator Castley.
Thank you very much, Mr. Chairman. And thank you, Senator Carter, for bringing this bill. I have a question because we heard a similar bill, although it takes a different approach, I think, to the same issue with Senator McCrae's bill the other day. And a couple of the people who testified there are some of the same people who we were testifying here. And so I think, Mr. Flowers, if I can direct this to you, but actually anyone can answer, do you think that these are a complementary approach to the same issue, or do you prefer one approach over the other?
No, I think that, as I said earlier, it's a matter of doing something, not just throwing anything. I think there needs to be some strict concern in response to these calls. Currently, there are not. As I mentioned in the hearing earlier this week, it seems that I know specifically in Howard County, there is a policy that the police can follow when people make false calls about rape and this kind of thing. That they do to activate a response to that. And they can use that same policy on other false calls, but they do it very subjectively. This would be the law. So I'm not saying I choose one over the other. I do, they can be merged to have the same effect. But the concern is that it's happening and it's causing challenges to people who shouldn't be going through this nonsense.
No, I understand that. I just think this is an interesting way of approaching it through the hate crime statute. And because you are linking it to the hate of or action because of a particular group.
I see your point. Well, I don't think that Ms. Chandri would be here, or I would be here if we didn't have experience.
Sure.
And I'll also say, you as well, you have experience with people targeting you because of your ethnicity and your racial background. And if that's viewed through a lens of hate, then there should be a response to that.
I guess I want to compliment the sponsor. I mean, it's sort of an elegant way as opposed to the civil liability approach through the hate crime statute. So I just thank you. And a couple of people have mentioned the educational piece of this and Mr. Oppenheim, but that's one of the reasons that we introduced and this committee passed and this body passed Senate Bill 220 this year, is to give judges the options to prescribe education for folks who are convicted under the hate crime statute. So thank you. I think that is a very interesting approach. Thanks.
Thanks, Senator Hedelman. I want to say that I took a minute to get to this point because as Mr. Oppenheim said, and as many of you know, first of all, how bizarre for me to be on the same side as the state's attorney, Mr. Schellenberger, and on the opposite side of Todd Oppenheim from the Office of the Public Defender. But I do believe that this bill would be effective to address the issue at hand, because there would already need to be proof that there was a false statement, and then this is simply an enhancement. And you have a situation as clear as Central Park where she says, I'm going to call the police and tell them you're an African-American threatening me, and then she does it. I mean, that's the kind of situation where that's pretty clear. I realize there will be other situations that are not going to be as clear, but like we do in all the other areas, we do have to go on faith that there will be some integrity within law enforcement and the state's attorneys at what cases they bring.
All right. Sorry, Senator Castley, you're up.
Thank you, Mr. Chairman. Just a quick question for Mr. Schellenberger. Is following this bill through, and you have it in front of you. You have the whole in front of you, Mr. Schellenberger.
Yes, I do.
Look on page 2, and then down at line 17 and 18, and then it says commit the violation of section 1 that except as provided in section II or I involves a separate crime that is a felony. So, and then the next one says results in the death of the victim. So that one I understand, results in the death of a victim. You make the false call, something goes wrong, and because of that, the responding officer, I don't know, somehow somebody gets shot or something like that, and it wouldn't have happened but for your call. And I'm just trying, so it involves a separate crime that is a felony.
So Senator, I've been struggling with your question because there would have to be another felony that's involved with the false statement. You are correct. I would say in 90 to 95% of the cases, it would be just a false statement, me proving it's false, and me proving it's racially motivated or the other factors. More likely than not, 90 to 95% of those cases will be 3-year misdemeanors. I have been trying to come up with the concept of a felony and how it would fit into this. I think every time I always think you're never going to see something happen, it happens. And so
I only ask because we've been on the consistent theme in this committee of not overcharging, and certainly I can see the 3 misdemeanor 5,000. That ought to be a heck of a slam to somebody. It's a little tougher to see the felony side of it. I mean, certainly if it results in a death or the individual was severely, I don't know, beaten or something like that, I could see that. But
and that would be the more likely scenario, is that they made a false statement. This person just kidnapped me, and the police come rolling in and they see the two of them together. The person has something in their hand. It's dark out, and the officer then thinks he's saving a victim, and he's not, and shoots the person. That could potentially, obviously, have resulted in the death, obviously, and so therefore that wouldn't have to be a felony. The false statement underlined the death. But what Senator Carter did, which was very clever, she took an existing statute, the hate crime statute, that we've all dealt with for years, and has inserted in a statute that requires motivation, me to prove motivation, has inserted the concept of a false statement based on motivation. What you're focusing in on is the crime based on motivation. So that's the way we used it before. They were kidnapped because of their race. They were kidnapped because of their sexual orientation. That's a felony. Therefore, the motivation plus the felony leads to this sentence. When we're talking about a false statement, there's going to be another step, and I'm going to have to prove that step. So I think this is very well structured, but I do understand your concern, but I don't think it's really a concern. I think it's just the way it's structured.
Okay, thank you. And then finally, just as an officer of the court as well as a senator, I just want to comment that I do find it distressing to have the Office of the Public Defender come in and make statements like this. The entire justice system is flawed from beginning to end, and it's unequal and it results in unequal and unpredictable justice. I just think that such blanket condemnations of our entire judicial system are unwarranted. Does it make mistakes? Sure it does. We just finished passing a bill in the Senate to provide financial compensation to people who were wrongfully convicted. But as someone who's toured the entire world and spoken to people throughout the world, lawyers and judges, I stand very proudly with our flawed justice system. And I think that we all should as well work as hard as we may to try to correct those flaws. I don't think it's something that we ought to denigrate into the public. Thank you very much. I appreciate your time.
Thanks, Senator Castley. I'll just say that the public defenders see the worst of the worst of the worst of the worst justice system on a daily basis. And in representing indigent clients, they see the greatest imbalance of justice with respect to indigent people, as we know. So I'm sure that Mr. Oppenheim is just speaking from his lens of what he sees on a daily basis.
Well, I think as members of the bar,
our great
it's our burden to rise above that. Right.
All right.
Thank you.
Excellent. All right. Looking around the Zoom room for further questions, seeing none from members. That will then end the testimony in the hearing for Senate Bill 400. We'll now move on to the final. Thank you all very much. Thank you. We'll now move on to the final bill of the day. Senator Carter with Senate Bill 420. Senator Carter, you're up.
Thanks again for hearing this bill. I think it's a really good bill and a step in the direction of treating drug addiction as a public health issue rather than criminalizing addiction. It's kind of one other step in that right direction. So Senate Bill 420, we've actually heard it before, but frankly, since we heard it in the past, there have been some changes made that I think make it more palatable for some of the people that had skepticism on this bill. It no longer makes it a criminal offense to possess syringes and other items commonly used to prepare and consume illegal drugs. Specifically, it decriminalizes the possession of drug paraphernalia used to inject, ingest, inhale, and otherwise introduce into the human body a controlled dangerous substance by removing such devices from the definition of drug paraphernalia. In addition, the bill reduces the penalty for a second violation from 4 years of imprisonment to a fine of $25,000 down to 1 year of imprisonment and a fine of $1,000. Research shows that those who fear arrest for paraphernalia are more likely to share and reuse supplies such as dirty needles. But if it is legal to possess drug administering materials, drug users will be safe to get clean paraphernalia rather than reuse their supplies. They would rather run the risk of infections such as HIV and hepatitis than hazard an arrest. Imagine that. Imagine that. Imagine, risking HIV and hepatitis rather than subject yourself to potential arrest. Because possessing such paraphernalia is illegal, there is intense pressure to ditch used supplies immediately rather than hold on to them until they can be disposed of properly. Dumping used materials in the streets puts the general public at risk, not to mention it's an eyesore and a health hazard. The first thing a police officer asks someone when they're about to search is, do you have any needles or anything else that can stick me? If possessing drug paraphernalia like a needle is illegal, it is less likely someone will admit to it. This puts the officer in harm's way. People involved in syringe service programs are still getting arrested and charged, even if such cases charged under the current law are typically dismissed. The process of being arrested and charged itself is punishment. It is enormously disruptive to the person arrested. Having to go to court takes time away from their treatment. Having to meet with their attorney can cause them to miss a dose of morphine. Buprenorphine, sorry. Buprenorphine. My eyes, so I'm shortening it to morphine. Recovery is a frail process. Any disruption could derail it entirely. Additionally, unnecessarily going to court ends up putting needless financial burden on the state. I would ask for a favorable report on this pretty common sense bill. Thank you.
Excellent. Thank you, Senator Carter. And we will have, for your primary witness, Golovetti, you're up next, Ms.
Thank you. Thank you, Chair Smith. Hello, everyone. You can hear me okay?
We can. Yes, you're good.
Great. So yes, I am Rajani Goodlovoletti, Director of Mobilization with Baltimore Harm Reduction Coalition. Our organization has been operating for 10 years, led by the vision of ending the drug war and ending overdose. As Delegate Moon stated at his committee hearing on this bill a couple weeks ago, criminalizing drug paraphernalia is a modern day war on drugs strategy. The use, possession, delivery, or sale of paraphernalia to inject, ingest, inhale, or otherwise introduce drugs into the body is a criminal offense in Maryland unless an individual is enrolled in and obtains supplies through a syringe services program, which we call SSPs, approved by the Maryland Department of Health. Speaking on behalf of one of the largest SSPs in the state, I'm going to tell you, proving that you are one of our clients is confusing and applied very differently when up to discretion of individual police officers. This bill would remove criminal penalties for paraphernalia used to consume drugs such as crack, cocaine, heroin, and fentanyl. In 2015, just to clarify, MGA did pass legislation to decriminalize cannabis-related paraphernalia. But in the 3 years following that significant decision, Maryland district courts still saw over 36,000 case filings for possession of drug paraphernalia used to consume other drugs. 11 states have removed certain items from paraphernalia statutes in a similar fashion as this bill. So SB 420 reduces legal barriers to syringe access to align criminal law with widely accepted public health practices, saving costs, stopping unnecessary arrests, and really improving the collective impact of drug treatment outcomes. So to say about BHRC, our program, Baltimore Harm Reduction Coalition, we are one of 16 MDH approved SSPs in Maryland. Between July 1st and September 30th of last year, our cohort of 16 SSPs collectively distributed close to 900,000 syringes. That is community access to close to 1 million tools used to improve personal and public health in just 3 months alone during COVID. At BHRC, we provide outreach at 8 sites per week. During the entire year of 2020, BHRC distributed 245,510 syringes over the course of 6,102 interactions. During those thousands of interactions, that was 5 minutes? Oh, sorry, I'll keep talking.
Yeah, if you briefly conclude, yeah, apparently that was 5 minutes, so.
Oh, okay, well, so I will, if it's okay to.
Briefly conclude, yes, please.
Okay. So as an overdose response program, I just wanted to say it's really important we make sure to offer and provide naloxone each and every time we interact with anyone, giving out at least 3,600 Narcan kits last year alone. And I will admit that in addition to this, we provide supplies to reduce transmission of bloodborne diseases, including safer smoking and safer snorting kits. So in 2020, we provided 704 smoking kits and 2,484 snorting kits. I thought it was really important to name that because since starting to provide those supplies, which this bill would cover, we have seen clients switch from injection to smoking or snorting, which is good for public and personal health. You can see in the written testimony all the public health benefits from that. The last thing I really need to say is in our current situation, it is expected that when stopped by police, people already marginalized by anti-drug user stigma can successfully advocate for themselves using this small piece of paper. That is hoping you are interacting with the rare, unbiased, by the book armed officer who has somehow memorized paraphernalia law. We spend a significant amount of time working with our community members to strategize around those issues, potential police interaction, when we could be making even more referrals and giving out even more supplies. So that is why we need this bill, which is a simple fix for that.
Thank you.
I urge you to pass SB 420.
Thank you very much. Thank you. All right, next we'll have Mr. Hilliard. You are up next.
Thank you for this opportunity to testify today as a retired major with the Baltimore Police Department and as a speaker for the Law Enforcement Action Partnership. I am here to support SB 420. Fortunately, we are finally learning that arresting people for drug use does not stop overdoses, disease, transmission, or drug-related crime. In fact, it is counterproductive because it makes people hide from the authorities, share syringes, and fail to report crimes. We are moving in the right direction by establishing syringe access programs because they reduce HIV and hepatitis C transmission without increasing drug use or crime. It's time for our state to take the next step and decriminalize paraphernalia possession. There is no public safety rationale to keep arresting people on this charge. In all my years of policing, I've never seen a serious threat to public safety be resolved by a paraphernalia arrest. Decriminalizing syringe possession would also help patrol officers who are at risk of accidental needle stick. Every time police make an arrest, we search the person before detaining them. As we pat them down, we ask the suspect if there's anything in their pockets or bags that could hurt us. Suspects will often lie if they're in possession of a syringe, hoping to avoid a paraphernalia charge. Researchers have found that 1 in 3 police officers are stuck with a needle while on the job. This bill would also reduce syringe littering. When we punish people for syringe possession, they do not risk carrying a used syringe with them to dispose of it safely. Instead, they leave it wherever they use it, in a park, in an alley, or in a public restroom. We shouldn't have to worry about our children playing barefoot in the park or our custodians being stuck by needles at work. Thank you for this opportunity to speak to you today, and I yield my time.
Excellent. Thank you very much. And next we'll have Ms. Winder.
Thank you. Good afternoon, Chairman Smith and Vice Chair and committee members. My name is Noelle Winder Newman, and I am the Deputy Division Chief of Misdemeanor Jury Trial in the Baltimore City State's Attorney's Office. I'm here today to provide support for Senate Bill 720, and thank you, Senator Carter, for leading this effort. SB 720 will essentially decriminalize possession of paraphernalia for personal use of controlled dangerous substance. Being a prosecutor for 15 years and prosecuting crimes ranging from homicide and rape to simple CDS and minor traffic, I have personal knowledge of how this charge is used and why there is a need for this bill. Decriminalizing drug paraphernalia begins the act of treating drug use as a public health issue. It will prioritize health and safety over punishment and begin to reduce the stigma associated with problematic drug use. Since many items that are characterized as paraphernalia have multiple uses, these laws have been subject to abuse, allowing police to be very selective in their enforcement, disproportionately harming communities of color. Therefore, it is also a racial justice issue. At the state's attorney's office, we see examples of this consistently in court. I saw this firsthand as a young prosecutor trying misdemeanor cases. It was an average day in court. I was waiting to call my own case while another prosecutor was at the trial table calling the number of plea agreements. When he stated his offer to the judge for a particular defendant, the judge called to the prosecutor's attention that he had 2 similar situated defendants. Same charge, possession and paraphernalia, same buyer facts, same record. Only difference was their race and their address. The Black defendant lived in Baltimore and the white defendant was from a surrounding county. The white defendant was given a PBJ and the Black defendant was offered a split sentence that included jail time and a period of probation. As a response to the judge's inquiry, the prosecutor withdrew his offer and only went on the charge of CDS for the Black defendant, the same offer he extended to the white defendant, giving both PBJs. The prosecutor was embarrassed, but in that moment did the equitable thing and checked his disparity and his bias. He used his power of discretion. The judge used hers too, remarkably, and she also used her judicial power for a teachable moment. However, the prosecutor and the judge were not the only one with this power in this case. The officer also has that discretion as well. This could have been a very different outcome, an unjust outcome, if it was a different judge and a different prosecutor. However, this is only chipping at the wall case by case.
Time.
Oh, may I finish, close out a little bit?
Yes, very briefly. Please.
Okay. What we need is a change in the law to address discriminatory enforcement statewide. In summary, charges of paraphernalia are part of the outdated approach, and this SB 720 is a needed step towards ending discriminatory enforcement of drug-related laws throughout the criminal justice system. And for that, I pray that the committee passes this bill for the reasons stated. Thank you for your time.
Thank you very much, and thank you for your testimony. Thank you for being here with us this afternoon. Next, and finally, we have Mr. Scott. You're up.
All right, how you doing? Thank you for having me to speak on behalf of MPAC, which is Maryland Peer Advisory Council, and I'm here to speak in support of Senate Bill 420. Thank you, Senator Carter and Chairman Smith, once again for having me here and allowing my testimony. As a member that's been in the recovery on the path of recovery and a part of the recovery community for over 25 years myself. I know what it is to suffer with the disease from drug addiction. So I'm speaking personally from my personal experience. When you're it's been defined as a disease, and that's where I think the problem comes in at most, that everyone believes that it's a crime that everyone is committing. But if you look at, you have hypertension and you have these other diseases that people suffer with, they have to get their medication. So treatment is the best way to recovery for someone suffering with a substance abuse disorder. So if we criminalize everything that is involved with their use, as it relates to the disease, as far as the needles, the syringes and everything like that, and as far as any type of paraphernalia that comes along with it, like the what they use to smoke the crack with, or anything that they're using, straws, anything. We have to understand that laws are made to put in place to protect the community and protect the individuals, and also with the police as well. We have the police doing more work than necessary. There's bigger things they could be worrying about right now than chasing someone, because if someone has on some drug paraphernalia on them, they're afraid to get locked up. They're going to run from the police, and then the police have to chase them down, and it can cause someone to eventually get hurt just because this person is suffering with a health issue. So, and then we have to consider there's children in our communities, so if somebody uses drugs and they don't want to get locked up, the first thing they're going to do is throw the needle down in the street or throw down the empty vial of crack in the street. And the child playing is going to pick that up and potentially harm themselves. So we need to decriminalize this bill so that we don't have to face those type of issues any longer in society, because since 1987, it's been deemed a health condition, So just like any other health condition, we need to look for ways to treat it as opposed to treating it as a crime. I mean, just look at the new COVID pandemic. Right now, we don't know much about that disease. We've been learning more about this disease for decades.
Time.
In closing, I just want to use that as a factor as far as the COVID-19. They're letting people out due to that for harm reduction, within the prison system. So I don't see why another disease that's been around for decades that we've been dealing with, you would want to put someone in prison for. We just need to decriminalize this bill so that people can get the recovery they need and everything, so that society can be a better place, as opposed to people being criminalized for having a disease. Thank you for allowing me to speak.
Excellent. Thank you very much, Mr. Scott. Thank you for your testimony. And with that, that'll conclude the testimony for Senate Bill 420. We'll now turn it back to the committee for questions. And seeing none, that'll conclude the hearing for Senate Bill 420. Thank you very much, Senator Carter, and thank you to the panelists. So that'll conclude the hearings for the day. We have a voting session. So I'm going to give members 1 hour until we go vote. So let's meet down in the committee room at, let's say, 5 after 4. Remember, we can only be there for 2 hours at a time. And so if we need additional time, I'm proposing that we do tomorrow morning at 10 o'clock before session. So if we need that backup time, we'll have tomorrow morning. So please be in the committee room at 5 after 4. Senator Hettleman, you've got a quick question. Go ahead.
Am I correct in that we haven't gotten any amendments distributed before? Because I don't have anything.
I think that's false.
No, it's not false. We're still getting everything together.
Okay.
So I'm fine. I just want to make sure I didn't miss something. So we're considering everything in real time. Yes?
Sandy, I guess that's right, because we don't have the amendments.
And Jamie's getting the pile together, and as soon as he gets everything together, I will scan everything in and send it out.
Just make sure everyone look, like we asked everyone to get in 24 hours in advance so that we could distribute them earlier. But when amendments come in later, then that pushes the whole process back. So that's not staff fault.
I'm not saying it was. I just want to make sure.
I know you weren't saying that. I just want to make sure that just out there. All right, Senator Lee, then Senator West.
Hello. Yeah, I got a similar problem as Senator Kettleman. I hadn't been getting any amendments even last week. Is there any way that I could be sent the amendments by my personal email too, in addition to the official email, just to make sure that my office and myself, I'm able to obtain them prior to the voting sessions. Thank you.
Excellent. Thanks. We'll pass it down to Sandy and then Senator West.
I'm sorry, I need to confess in advance, I have been so busy. I simply have not had a chance to draft amendments. I had 4 bills yesterday, 3 more bills today. I've got to travel back and forth. I've got to get some sleep. I basically said this in an email, and I sort of got chastised a bit from the chair because the email is available for public viewing, or could be available for public viewing. But I may have to ask that the Leobor bill be held over so that I can spend some time actually preparing some amendments to it.
No, excellent. No, obviously, we'll accommodate folks. I travel back and forth every day. We're all very busy, so I understand. And for the email, it was just a PSA. I mean, you can have the conversation just as a parenthetical thought. You guys know that's there. So it wasn't meant to chastise, just information. Okay, great. So see you all and for about 5 after 4.